తన తండ్రి కబ్జా చేసిన భూమిని అప్పగిస్తా, కోర్టులో త్వరలో డీడీ రద్దు చేయించి కలెక్టర్కు అప్పగిస్తా, కబ్జా భూమిని కూల్చేయడం సంతోషంగా ఉంది. ఎమ్మెల్యే ముత్తిరెడ్డి కూతురు భవానీరెడ్డి. నిజంగా కూడా గొప్ప విషయం ఆమె. ఇక హెడ్ కానిస్టేబుల్ ఆత్మహత్య, తన ఇంట్లో ఉరేసుకొని సూసైడ్. సంగారెడ్డి జిల్లా కేంద్రంలో ఘటన. మోకిలా పిఎస్లో విధులు నిర్వహిస్తున్న మాణిక్యం అంటూ ఒక వార్త కనిపిస్తుంది. చాలా మంది పాపం కానిస్టేబుల్ బాధపడుతున్నారు. చాలా సఫర్ అవుతారు. అంటే అసలు జీతాలు వస్తలేమంట. నాకు చాలా మంది ఫోన్ చేస్తున్నారు,
జీతాలు 10 వస్తున్నాయి.
తర్వాత ఇంకోటి ఏంటంటే వాళ్ళకి సిలిండర్స్ రావాలి, 2 సిలిండర్స్ రావాలి, అవి ఇవ్వలేదు. తర్వాత టీఏడిఎల్ ఇవన్నీ ఇవ్వట్లేదంట. దీంతో చాలా మంది పాపం కానిస్టేబుల్ బాధపడుతున్నారు. చాలా సఫర్ అవుతారు. అంటే
previous mentioned is very good. 1 to 6, 9 to 18, 19 to 30, 31 to 40, 41 to 51.
Lordship, serial number 47. Lordship, due to some miscommunication, we could not supply the copy to the registry. Lordship, grant 1 or 2 days time, we will supply.
Orders granted. Appropriate orders will be passed.
Oblige.
Order to supply. 47. Time to supply copies further extended for the period of 2 weeks. Or 1 week, JBS, 1 week. Yes, please. 1
Oblige.
week. Yes. Next.
52 to 61, 62 to 69, to serial number 68. So this, that the Panchayat has already sent a proposal to state government and requesting for some shop.
Yes, some time will be granted. Yes, please.
70 to 72, 73 to 77,
76, I'm appearing with Ms. Juthani, seeking priority. Please.
Yes.
Leadership, if we are the contesting party, we are not in.
Who is the party?
I'm sorry.
Who is the contesting party? State?
Contest? No. State is not there. Universe.
Yes. Are you ready?
State-
You are appearing? Are you ready with the matter?
No,
I have
I'm
understood.
appearing with her.
You are appearing with him.
With her.
Okay, I'm sorry. Yes. Yes.
78 to 86, 87 to 97.
80 number.
Serial number 80.
Yes, note
My learned
okay.
senior
Yes,
friend,
yes.
please allot it. Even though
Number
I'm
80.
not joining it, even I'm ready with the matter.
Oh.
Maybe even
Take
take
it on
up,
record. Take it on record. We'll keep that.
please allot it.
Yes.
Serial number 95.
What's the serial number 80 in the
Private. Serial number 95.
Yes. Yes.
serial number 88? I have granted to withdraw settlement and been arrived in this month.
80
88.
at the request of Honorable Mr. Mishra. Permission granted. Petition stands. લઈ લેજો order. બરાબર છે. એટલે withdrawal order છે આપણે કરીએ છીએ. Yes.
98
Withdrawn.
to 104.
Serial 98. Serial number 98.
એક કશું. Serial number
98.
હા.
Request for hearing on the 17th.
હા. Ready with the matter? Yes. Priority. Yes.
Please.
Serial number 99.
Yes.
On matter pertains to our family culture and culture collection recollect twice for the directors to file reply to the
My
government.
learned friend
She is
appears
not
for the timing lordships, a week or two. My learned friend appears, she must have gotten her instructions. Today she is indisposed.
On 6th, Lordship allocated on 6th.
6.
Please.
6 July.
Please.
Yes.
Alright.
Serial number 100, my lady.
Yes.
The similar
Six.
situated matters are coming up
98 on
tomorrow.
230 because they are available on 230.
98. Cinema, Mr. Naroti is appearing. He will be available at 2:30. Yes. At 2:30.
230.
Yes.
My lady, serial number 100, the 3 other matters are coming up tomorrow. They are connected matters. It may be kept tomorrow. Obliged.
105 to 113.
105, your lordships.
113. 111. Triple one. I'm requesting for priority.
Yes.
Already informed to the.
Yes, please.
105, I'm seeking priority.
What is the matter?
His salary has been reduced. I'm only pressing the civil application today.
Yes.
Serial number 113, seeking priority.
Serial number 106, I have informed the others, Mr. Munsha as well as the government, I'm seeking priority.
Serial
number 110, I request for priority.
Lordships, here, the say of my learned friend is that it is covered.
Yes, sir.
I'm yet to get my instructions. Any short accommodation, your lord.
Yes.
And she's widow without a consent.
Understood.
I follow short accommodation.
Sometime. Just a minute. Not even Exodus my time. Yes, please.
100.
114 to 120.
Madam, serial number 112, madam.
Yes.
Madam, it's a widow pension matter, madam, but unfortunately we could not inform the other side.
Some date will be granted. Yes, please.
Serial number 114, your lordship. I'm requesting for 230. I have informed the other side. The matter is pertaining to execution of recovery service. There is already an order. We are not a party. Miss Vaishnav, nearly Vaishnav, on the last occasion, she had given assurance that it will be paid.
Will not exactly at 2:30, but we'll try to take up. Yes.
If it can be disposed of in the direction that you kind of in the product.
So have you informed other side?
Yes, sir.
Then you come at 2:30 with her. I will take her. Yes.
121 to 130.
Sorry.
131 to 140.
Hundred and fifty-four, there is notice for final disposal.
Just a minute.
I'm sorry.
Who should- Yes, please.
121,
Yes,
there is notice for final disposal.
yes.
No replies filed as yet since 4 times adjourned matter. Is adjourned.
Yes, who appears for the state at the request of London AGP as a last chance, do I record as a last chance to file reply? Yes, please.
134. I request for priority. This is that short issue whether or not workmen have been granted identity cards and only the government had to take action against the airing company. That is about.
We'll try to take.
I was
up
informed
notice.
about this in the morning itself, your lordships. Any short accommodation.
Adjourned at the request of agent. Yes,
Please.
141 to 140.
Serial number 242. You have got instructions to appear for the respondents and counters.
yes, adjourned at the request of Mr. Thakkar states that he has instructions to appear for respond number, only one respondent.
Because the.
Respondents
What?
at workman, at his request, amen, huh? At his request, adjourned to so and so. Yes, please, next.
148 to 157. 158 to 168. 169 to 176.
Lord, 174, Milord.
Priority.
Priority, Milord, they are all senior citizens, around 68
How
people.
much time will it? take?
Milord, I'll not take more than 15 minutes, 10 to
Who
15.
appears for the state? But it was kept, I think possibly.
Yes, Milord, it
Friday,
was-
I couldn't
yes.
take. Just go through, try to have it. We'll take it as a priority. Let 2:30, at
Very
least 2-3 matters be over and then we'll
Please,
see their issue is in relation to pension.
and covered, Milord. I'll point out.
Just
how
look
is
into
covered.
it, we'll try to, yes. At 2:30, but after 2-3
Or may I
matters,
request, Milord, let it be tomorrow, it may come in the purpose
Yes.
report, so.
no requirement of purport, but હવે તો purport માં જ આવશે ને. તો કાલે રાખી. Yes,
Please,
27, yes.
grateful to you.
Serial number 171.
170.
There also the proposal has been sent and my request for some short date.
Yes,
Lordships.
yes, at the request of London request for the petitioner. Yes,
Serial number 169.
Yes.
Requesting for priority.
Here we have already filed the reply and during the second of I have some personal difficulty.
at the request of,
Any shorter date even day after.
One
before for
is
any other day.
one person is right and another is attaining superannuation age.
what is
So
the
far as the
issue?
issue is concerned, the benefits has been given to them from X date, they are claiming from Y
Y
date.
date.
That is the only difference.
Understood. Upon it, yes, adjourned. At the request of London request, Mr. Pandya, yes.
Number 177 to 181. And from 182 to 191 of the subdivision.
All below, regular order of removal within a period of 6 weeks. Yes, please.
Passport board 1 to 8.
My serial number 2, here I'm seeking permission to withdraw my liberty to file a press petition. If amicable settlement is not reached with logical end.
No conditional withdrawal.
Yes, yes.
That is your right. But withdrawal is never be
If we
conditional.
withdraw will be again, they difficulty.
Then you don't withdraw. Then you don't.
They assured my lord, if I get withdraw, then and then I'm retired in next month. Therefore, they assured, therefore I'm saying my subject to that. It is not happened, but it's a government officer.
That is,
Suppose they.
but withdrawal cannot be conditional. Who appears for the other
Lordships,
side?
I'm here on her behalf, but the same request that not conditional, your lordships.
At the request of, no, sorry, London request, Mr. Paresh Brampad for the petitioner states that he is instructed by his client to withdraw the this petition. Permission short for withdrawal is granted. The petition stands disposed of as withdrawn.
Please, your
My
lordships.
one request, can I think my lord may say that at this stage I'm.
At this stage, 100% at this stage.
Public-
He is
public-
withdrawing at this stage, huh? He has instructions to withdraw the petition at this stage. Yes, just a minute.
9 to 12.
Acha, you are on the board, in the board. No, wait for some. Yes. Fatima, yes, please.
I apologize for missing my turn. Serial number 94. Here I'm requesting for priority. I've informed the other side. Serial number 94.
Those who have missed your turn, please provide a sheet with special civil application number and serial number. So please.
Something different. So matter serial number 140 and 149. But these are the matters, wherein the petitioners were appointed in on the sports quota. Subsequently, government told that it's a false certificate. But the issue is decided by our Honorable High Court up to the appellate bench. We have produced the order. Subject to your lordship convenience, the similar order can be
Who
passed.
appears?
Sorry.
So for
148, 149. 603, 601.
what are the orders passed by this court?
In my favor.
But what are the directions?
The direction is that since the verification of the documents were made by the government, now government cannot take this stand and they cannot be now dismissed.
141 and
149,
149 only.
148 and 149.
148 and 149.
But then I total.
I'll just get the copy because.
Then not tomorrow. You have not informed other side. Then without informing,
Not
please
today.
don't
Yes,
action.
yeah,
Please.
Serial
Yes.
number 40.
Adjourn at the request of AGP Karnataka.
Shortest is
They will inform you.
Serial
Yes.
number 48, your lordship. By consent, I'm requesting for
Sorry.
48.
You want time?
Please, your lordship.
Yes.
By consent,
40 by joint request. 48.
please, your lordship.
May I mention, madam? Serial number 83, my lords. Here it is a senior citizen, my lords. We wanted to make a request for priority, but ultimately there is not even appearance file, my lords.
Yes, who appears for the state?
You probably have instructions for the time.
At the request of London AGP.
Sure.
At the request of London AGP. Adjourn. Yes, please.
Your ladyship,
Just a minute. You please wait your turn.
I'm requesting for circulation of one matter for tomorrow. It pertains to camp. My application is not accepted and tomorrow and day after DPO is going to verify the documents. Again, it won't be accepted. Hence, I'm requesting for tomorrow.
Yes, please.
Obligatory.
Yes.
And typed copy may be dispensed with the
Legible.
legible.
Undertaking and
Please,
Yes.
oblige.
Lordship, serial number 53. Arshit Dolaki appear in one of the respondent and a file exhibit, but not showing the names. And today is not coming, so may I request him for some sort.
at the request of London advocate. He appears for whom? This
Sudhanshu
phone
Jha.
number?
Sudhanshu Jha.
At the request of this foreign. Chalo, yes.
Lordship, may I mention?
Serial number 59, mentioning on behalf of Mr. Jani, with consent I'm requesting for.
Yes. Yes, please.
Lordship, serial number 108. Requesting for priority, my lordship.
I told that those who have missed that turn, please provide the sheet.
Okay.
Yes,
Pardon. From circulation, my lords, for tomorrow.
then no priority.
Circulation for tomorrow, my lords. Similarly, you read 5 matters, my lords, they have passed an order. One was left out. I'm requesting for tomorrow and only request for
But what is the urgency? Let it come in due course.
5 matters, my lords, have
That
been
is
disposed. Only request is, my lords, the objection that has been raised is regarding one small black line, which in fact is completely legible, my lord. So if at all circulation is given with dispensing with that black spot, because frivolous objections are being
Pages.
raised.
No, you can't say frivolous objections. Objections you give dispensing. If registry, it will be dispensed with, but entire thing is, the paper is legible.
Legible. It is as clean as this paper.
Come in due course. Only dispensation. Yes, please.
Please, my lords.
Yes. Those who are having same request, that identical issue with the, please provide serial number with special civil application or number, otherwise no orders will be passed. Otherwise it gets mixed up in so many matters. So serial number
20.
20.
Similar matter, police authority, color vision.
That is true. Miss,
Yes, I
provide serial number, yes,
Otherwise, every time.
serial number and SCA number.
I know.
हमने આપી તો નહીં લખીને આપશે તમે ના લખતા હવે તો આજ આપજો નોટિસ સેમ સિમિલર ઓર્ડર બરાબર serial number 2
1 of 23 in SCA 10459 of 22. It's a program.
Please.
Yes, what is your prayer?
Prayer
Want
is
to-
only to allow me to appear in the camp, participate in the camp.
Why?
I
Why?
already filled up the form, madam.
Now they are raising objection as there is a petition pending before these honorable court. They are not allowing the present petitioner to participate in the camp. Earlier also,
First, what is your eligibility to participate in the camp?
I am as per the new resolution, which is updated 2/6/2023, that is on page number 10. This is a intra-district transfer camp, which they have scheduled, and wherein, as per these GR, they have permitted the applicants who are having a vacancy in their mother school. So I have filled up the form as per the criteria, the schedule, which is published by them, and now they have to issue an order. But prior to that, they have to scrutinize the applications which we have filled up online. Now they are saying that as the petition is pending before these honorable court, they will not allow them to participate. Therefore, my only request is that I may be permitted to participate.
Yes, who appears for the?
I am for the district pension.
Yes.
Here we have not objected to participation, but there is an interim relief of this honorable court. If
Yes.
suppose we have to breach that,
Yes.
then we have to face. That's why
Yes.
15D, they
Yes.
have not stated what is 15D. But Lordship, please to see the
Where?
first annexure. Page number 8. There shall be an interim relief in terms of para 15D and 15E till then. That is 27/6/2022, which they have stated in the particular paragraph. Page number 3, para number 2.
Page number.
Yes,
civil
civil
application.
application, Lordship. Page number
Yes.
3, para 2.
Yes, please.
The applicant state that and submit that the aforesaid petition is pending before this honorable court, wherein the after hearing the parties, this honorable court has issued the notice to the respondent authorities and passed the interim order that the transfer order shall not be implemented. The
Just
copy
a
of
minute, you are reading where?
page number
Para 2.
Para two, sorry, para two,
I'm
yes.
married.
Yes.
Para 2. The applicant state and submit that the aforesaid petition is pending before the honorable court, wherein after hearing the parties, this honorable court has issued the notice to the respondent authorities and pass interim order that the transfer order shall not be implemented. So on one hand, that order we have not implemented, the applicant is as where he or she was.
Status quo.
Now what had happened? If suppose another petition, he or she to be joined and even selected. So in two places we have to do so. In these
Status
places,
quo means status quo, you can't. Just turn to the main petition.
Wherein the prayer clause
Please read.
start from page number 9, and the interim prayer granted by this honorable court is on page number 10. Clause 15D and E have been granted.
Yes, please read
Pending
that.
hearing and final disposal of this petition, the respondents may not show the vacancies of the retired teachers which are available from 31/5/2022 in the intra-district transfer camp of Pratik Saluda. And pending hearing and final disposal of this petition, the transfer order dated issued by the respondent in favor of the petitioner may be stayed. These, my lords, thereafter, after this order, my lords may kindly see the another order passed by these honorable court, my lords, that is on page number 9 of the civil application. Sorry. These application was also preferred for the participating in the transfer camp. Page number 9 is the order, and I have quoted the said prayer, my lord, 7B on page number 3 itself of my application.
That I saw,
Please.
but that prayer is along with other prayer.
No, my lords may kindly have a look. My lords. Page number 3, para
Yes,
3.
pending hearing and final disposal of the application. There is no-
Respondent or the directive permitted the applicant to participate in the work Bharat camp, which is to be held as per the communication dated so and so. So now also I am requesting the same, that I may be participate. If I will get the seat vacancy, then I
Now
petition-
go to turn para. See, you were granted the order dated. The order dated 14/9/2022.
Please, Your Honor.
You have granted interim relief in terms of para 7B Now go to main petition 7B.
No, that this is of civil application. Malad, I
7B of
One of 2022 civil
Malad,
application.
what happened, Malad?
What has been
After the order of 13/6/2022, which is on page number 8 of the civil application.
let me go to
Please.
one of 2022.
Yes.
In that there is no such the 17 para is not there.
No. In the main pit.
I don't know. Two of
Civil
22.
application 1 of 2022, wherein 7B was granted by the honorable court.
7B.
Yes, Malad.
Yes.
And that I have quoted in my application.
Please read that 7B from the main.
Please, Lord.
Yes. Pending
Pending.
hearing and final disposal.
Of this application, the respondent authorities may be directed to permit the applicants to participate in the work Bharat camp, which is to be held as per the communication dated 8/9/2022, and further to direct that the transfer order may be passed as per the seniority which order dated so and so. Plus, wherein these honorable court has granted the permission. That order is on.
Now here two differences. They are relying upon the subsequent government resolution, page number 10 of present civil application. 2/6/2023, wherein we have been permitted, who is having the vacancy in parental school, all have been permitted. But here difficulty would be there as per 15D and 15E. Even in Pratis Taluka, we have not shown any of the vacancy as per the 31/5/2022.
As on date of
Now difficulty on, yes.
that application would be like the vacancy is to be seen as on date of camp, and if vacancy will
certainly.
be available.
But 15D and is stated we do not shown the particular vacancy in Pratis Taluka. The teachers who are going to be retired on 31st May 2022. Now we are facing the difficulty, we have not shown. Now certainly they have a right to do so. But when interim relief led, they have to withdraw and participate. We have no objection. Or they have to say our interim relief.
File my undertaking.
That every matter.
The authority that if I will get the I will immediately withdraw the matter. On that condition, they can.
Because every matter.
Because earlier also these was happened, and these.
Certainly I can't run away. But now when administration we have
Just
to.
a minute, Mr. Patel. Your case is that now on 31st, that let's say vacancy is to be seen.
No, it is not so much. Vacancy is there.
Acha, it is there.
Vacancy is there. They are.
You want to go to your parent school?
Yes, because these they have introduced by 2/6/2023 only. Earlier, these was not there. So I have immediately preferred an application as per the inter-district transfer.
What about the undertaking if he gives that?
But in place of undertaking, they have to withdraw, and there are number of petitions where only a minute, sir. Number of applicants withdraw and participate as per.
You can't say hot and cold together. You said that I this civil application you are not pressing, and you will be permitted to participate.
No,
Petition you are not pressing.
yes,
Special civil application.
special civil. Certainly they have a right to 2/6/2003. We have to obey. Vacancy would be there. But now what had happened due to this interim order, since 2 years we have not shown any vacancy in Pratis Taluka. There are number of persons suffered.
So
that would be a
amount to violating.
That's why, ma'am.
Yes, you seek instructions.
Please, Lord. May keep it at 2:30.
You seek instructions.
I-
Yeah.
I-
You may be allowed to participate. Then there is no question. Once you
Certainly.
withdraw the
Yeah, Lord,
petition,
Lord,
we
yes,
will-
and we have permitted, but interim relief is there, and the government stated you have to
Yes.
see that no breach of the order of the interim. Lordship.
Please, and serial number 3 in the regular.
Yes. What are your instructions?
Period of time during which they were supposed to give the form, to fill out the. They are not, there is a false statement before this order. That the forms have been filled. I have it on.
Let's read what the client has appeared. Otherwise, I might not have.
None of the application forms are there in the civil application.
At 2:30 will,
Please.
votes will be, then if he is withdrawing, then question doesn't arise,
Please,
then,
But the fact that it's got-
then that is, it is his choice.
They may take.
They have to face the
Please, Lord.
consequence. Yes, next.
Number 2 orders are passed. Serial number 3. SCA 10695 of 20 please.
Identical issue, but the authority is not permitting it to participate in transfer camp, my lord.
What is the
Earlier, my lord-
reason? What is the reason?
Yes, my lord, earlier,
Transfer camps are to be held when, in your case?
in my case, my lord, it is started when, my lord, the verification of at district level would be completed by 28 June, my lord.
You will be governed by new transfer policy?
Yes, sir.
Yes, who appears? Okay.
This is the primary education officer.
Yes. Honorable Mr. MP Pandya for the petitioner issue notice. Yes,
Direct service, my lord.
direct service permit.
My lord. Returnable one, my lord.
Some date will be given, please, don't ask me.
My lord, then the petition will be in place, my lord.
When is
Day
it?
after tomorrow, my lord.
It can be done, please. When the, why you came so much belatedly?
My lord, my application just got rejected, my lord.
Application was to be filled up when? Which is the last date of
It's my-
application?
It's my lord.
અરજી તાલુક યસ તાલુકા દ્વારા અરજી વેરિફિકેશન 19/6/2023. યસ આધાર ચાર્ટ.
Then from Taluka it goes to the Jilla.
યસ
So that option is also there. If they have already filed their objection.
For a moment, if my lord would permit me, my lord, I would like to.
ઇશ્યુ નોટિસ
number
તમને
20.
કઈ જસ્ટ મિનિટ 26 એટલે first
Then, my lord, first, everything would be completed, my lord.
when it is scheduled on, it will
Yes.
go to Jilla
On
now.
the first July, my lord, order issue કરવાની કામગીરી.
તો ક્યારે છે આગલો એ પહેલા જિલ્લામાં જશે ને?
Please, sir, જિલ્લા લેવલ નું જે છે 28 complete થઈ જશે. Thereafter, it would be forwarded to the state level, my lord. 29.
Last moment you can't come and pressure is they also need to set some
એક જ મિનિટમાં ખાલી permission તો આપો સાહેબ. જે order I want to show that, my lord. Page number 13, my lord.
what permission you want now. Let's go to the merits,
Earlier,
please.
yes, sir. Earlier, my lord, one application was filed by me, by the petitioner in 2021, my lord. Where
Yes,
the petitioner, this is that matter, my lord, where I have mentioned that the petitioner is 44-year-old lady. She is widow, my lord. Having 8-year-old child and serving on an island, that is CR gate, my lord.
and she is not given a transfer.
She is not permitting to participate in transfer
Transfer
camp, my lord.
camps.
Page number 13, my lord. Earlier, when she was got her desirous place, my lord, the person who was serving there, she is challenged by of this petition, my lord. Page number 13, my lord. Please.
Yes, please.
Para number 7, my lord. Considering the fact that today whether the post of teacher in school number 8 is vacant or not, or whether the petitioner is entitled to transfer to school number 8 is debatable issue. Just to strike the balance between the parties by way of interim arrangement, responded by our director to maintain status quo prevailing at.
Therefore, she could not.
Yes, my lord, but this
Param
status quo
Divas.
is regard to school number
Let
8.
you serve, well, let it be on 28th.
Please, please.
Direct service permit.
Please, sir.
Serial number 4. SCA 1 of 23 and SCA 12088 of 20. Order is law orders.
Madam, on behalf of the Ashwini, madam, this A is for withdrawal.
See, yes. What's the good name, please?
Other case to withdraw this CM.
Other side is to withdraw. You are for whom?
And for respondents.
Gupta. The petitioner is to withdraw, but there is no one for petitioner. Who appears for Otis law officers? Yes, let pass over. Sorry, please.
Lord, serial number 3, if I can request DS, it can be.
Yes,
issued
today. Today.
Please.
Chandi karna apne tarat hi. Yes, today. huh?
Serial number 5. SCA 10273 of 23 must be for prior survey.
The issue of leave encashment and gratuity on Friday, this was there in us.
Only two prayers?
Yes.
Which department is this?
Same on, I think it's not that, but it's not on dates. Dates were to be given. You know, if I was permitted,
Yes.
dates I have incorporated in this.
Apoth-
So that- Except date change, my lord, everything remains same. Because there are 8 petitioners, the chart is prepared in this. Otherwise, this order which I have given, my lord, sir,
This one.
that is draft, but this
Apoth-
earlier order.
Yes,
Yes. Because it only
Upon
pertains to
verification.
page 2.
this is the order to be passed and these are the facts. Amathi facts lejo. Disposed of. Rule કરવો પડશે. Mr. Trivedi waves forthwith અને પછી
Number 6, SCA 10302 of 23, Mr. Martin.
Friday it was listed and it is for 7th day commission.
yes.
Page 13 is a GR. 1-3. Darkhas has been sent from the authority as per this GR.
It's a recommendation.
Yes,
It's a recommendation that law api shakase, then who will act? This see, recommendation is there,
Yes, subsequently.
but then you need to adopt it.
It has been adopted to.
So you seek instructions, I am, yes. Issue notice. For Mr. Bhavin Dhakkar for the petitioner, issue notice.
please not. I have a mess.
Yes, please.
So number 7, SCA 10305 of 23 years, it's not in the limit of constitution. Number 8, SCA 10318 of 23, Mr. Vikin Kumar.
Please, your lordship. Here, my lord, I am challenging the transfer of the petitioner from my lord Ikke Vidyalaya Patan to my lord Taluka Sankalpur Patan, your lordship. That too without considering the my lord their own circular of the government, your lordship. Kindly see my lord my transfer later, your lordship.
Just a minute. First, just narrate the facts.
Petitioner is my lord teacher.
Petitioner is working
Teacher, my lord, secondary school, my lord, appointed in 2017, your lordship.
from
Can-
where you have stated, page your petition memo. Yes,
2017, in a NHRE, your lordship, appointment later.
yes.
Then after I was transferred in 2022, my lord, from
Yes.
Surendranagar district to Patan district, your lordship.
Yes.
Kindly see my lord NHAB. Page number 14, your lordship. Now, then after my lord, kindly see my lord NHRC page number 15, your lordship. I transfer in the bio of general order, your lordship, as per couple transfer of the government scheme. Kindly see my lord page number 15, NHRC, your lordship.
Yes.
My lord, column number 2, your lordship.
Hmm.
Jyotika Ben Rasikbhai Panchal, my lord.
Ah.
હાલની શાળાની વિગત સરસ્વતી માધ્યમિક શાળા જંજામ તાલુકા સાંતલપુર to સરકારી શ્રીમતી કેકે ગુલ્સ હાઈસ્કૂલ પાટણ તાલુકા પાટણ કૌંસ લાસ્ટ કોલમ સરકારી દંપતી, your lordship.
Hmm.
Now kindly see, my lord, transfer
At present, you are at Patan.
Patan. Now my lord transfer to Santalpur, your lordship. That now my lord, then after my lord I become a permanent employee of the my lord government, your lordship. It is that order, my lord, page number D, NHR 18, NHR D page number 18, your lordship.
NHL,
18, NHR D page number 18, 18.
that is what?
This is the, I get the full script, my lord. Now, my lord, kindly see NHR page number 19, my transfer order, your lordship. That very important, your lordship. In the second paragraph, if my lords permit me,
So you were become regular.
regular, my lord, become a permanent, my lord. Now my transfer on the against the GR of the government, your lordship. It specifically mentioned that the husband who is husband and wife who were working in the fixed pay, they can also entitled for that. May I read the, my lord, transfer order, my lord?
Yes, page 19.
Page number 19, second paragraph. તાજેતરમાં માનનીય કમિશનરની શાળાઓની કચેરીમાં પત્રક નંબર 16 નથી 16/5/2023 શિક્ષકોના જિલ્લા આંતરિક ફેરબદલીમાં કેમ્પ કરવાની સૂચના મળતા ગત સાલ અને ચાલુ સાલે આવેલ અરજીઓના ચકાસણી કરતા ખાલી જગ્યાઓની માહિતી ખરાઈ કરતા શ્રીમતી પંચાલે ગત સાલે તેમની ફેરબદલીની અરજીમાં સરકારી દંપતીનું પરિસ્થિતિ 7નું પ્રમાણપત્ર રજૂ કરવાને બદલે નિયત નમૂનાના સિવાયના પ્રમાણપત્ર રજૂ કરી સરકારી દંપતીના અંગતના ખોટા લાભ મેળવી ફેરબદલી કરાવેલ છે. તેમના પતિ અમુક પાત્ર પત્રક 1માં ઠરાવની જોગવાઈ મુજબ નિયમિત ભરતી પ્રક્રિયાના નિમાયેલ ન હોવા છતાં ફક્ત 11 માસની કરાર આધારિત 25,000ના ફિક્સ પગારની નિમણૂક મેળવવાના આધાર રજૂ કરી જિલ્લા અન્ય શિક્ષકોની વ્યાજબી હકે ડૂબાડી ખોટા દસ્તાવેજ ઉભા કરી ગુજરાત રાજ્ય સેવા વ્યક્તિ નિયમો 1971 તથા ગુજરાત મુલકી સેવા નિયમો 2002ના જોગવાઈનો ભંગ કરે છે. This is the allegation. Now, my lord, kindly see, my lord, annexure G, my lord, page number 22, your lordship. This is the appointment letter of my husband, your lordship. It is appointed in 19 October 2013, your lordship.
Just a minute.
Page number 24 is the name, page number 24, my lord, name of my husband, it is mentioned that Himalaya Sankalal Panchal, your lordship. He was appointed in 2013, your lordship.
Just a minute, fellow.
Page number 22.
First read the first paragraph of page.
Yes, સરકારી પોલિટેકનિક ખાતે નીચે 10 સાલ ઉમેદવારની વ્યાખ્યાની જગ્યા પર માસિક 25,000 રૂપિયાની ફિક્સ પગારના કરારના આધારે ધોરણ 11 માસ અથવા જગ્યાએ ગુજરાત સહાય જેવા આયોગ દ્વારા નિયમિત નિમણૂકથી ભરાય તે બેમાંથી જે વહેલું હોય તેટલા સમય માટે પ્રસ્તુત આદેશમાં દર્શાવેલ બોલીઓ અને શરતોને આધીન સિવિલ વિદ્યાશાખામાં તેઓની નામની સામે દર્શાવેલ સ્થળોની નિમણૂક કરવામાં આવશે.
Yes, where are you figuring? Your husband's name is at
Page number 24, your lordship.
serial number.
58, your lordship. Himalaya Sankalal
Yes.
Panchal.
Then
It was appointed in 2013, your lordship. Now, my lord, kindly see the letter issued by the Polytechnic, my lord, where my husband is serving, your lordship. Page number, annexure, page number 28, your lordship.
yes, please.
May I read, your lordship? આથી હિમાલય સંકલાલ પંચાલ સિવિલ એન્જિનિયરિંગ વિભાગમાં વ્યાખ્યા તરીકે કેડી પોલિટેકનિકમાં પાટણમાં તારીખ 24/10/2023 થી ફરજ બજાવતા રહ્યા છે. તેમની ખાતામાં દાખલ તારીખ 24/10/2023 છે. તેમની પત્ની એક રાજ્ય કક્ષાના શિક્ષક એ બદલી કેમ્પમાં ઉમેદવારી નોંધાયેલ હોય અગત્યનો લાભ લેવા જરૂરત પડે ભાગરૂપે પ્રમાણપત્ર આપવામાં આવશે. Till today my husband working there, your lordship. More than 10 years. Now, my lord, kindly see GR of the government, your lordship. Annexure I, page number 29.
That is true. Once again, go to that transfer order, page 19. Why you have been denied?
That's is state that the DU partner said the DU false document. Your husband initially appointed for 11 months, but more than 10 years he was completed serving as a job, your lordship. It is mentioned and it is also made in my petition also, my lord. And government circular said that more 1 or more 2 years, my lord. My lord, transfer page number 19.
So you continued on
Yes,
contractual basis.
please, your lordship.
Time and again.
Time and again.
So
your
you
lordship.
were not on a.
No, permanent, not, my lord.
No.
But my lord, kindly see government's GR, your lordship.
Yes, please. Now in that
Page number
context, please,
29.
please
Annexure I.
read that.
Please, your lordship. સેકન્ડ પેરેગ્રાફ, યોર લોર્ડશિપ. સામાન્ય વહીવટ વિભાગના ઉપાય વંચાણે લીધેલ ક્રમાંક 2 સામેની ઠરાવથી તેમજ ક્રમાંક 3ના સામેના પરિપત્રથી દિવ્યાંગ કર્મચારી તેમજ કરાર આધારિત ફિક્સ પે. ઇટ ઇઝ સ્પેસિફિકલી મેન્શન ધેટ ફિક્સ પગાર નિમણૂક મેળવનાર મહિલા કર્મચારી ઓછામાં ઓછા 1 વર્ષની સેવા બજાવી હોય અને પુરુષ કર્મચારી ઓછામાં ઓછા 2 વર્ષની સેવા બજાવી હોય. આવા ઉમેદવારોને જો બદલી માટે અરજી કરે ત્યાંથી આવી અરજીઓ ઉપર વિચારણા કરી બદલી કરી શકાય તેવી જોગવાઈ કરવામાં આવી છે. નાઉ my lord, પેજ નંબર 13, પેરેગ્રાફ નંબર 3, your lordship. Next page, your lordship. Paragraph number 3, my lord. સામાન્ય વહીવટ વિભાગના ઉપર વિચારણે લીધેલ ક્રમાંક 2 સામાન્ય ઠરાવ નિયમિત ભરતી પ્રક્રિયાથી કરાર આધારે ફિક્સ પગારના નિમણૂક મેળવનાર મહિલા કર્મચારી ઓછામાં ઓછા 1 વર્ષની સેવા બજાવી અને પુરુષ કર્મચારી ઓછામાં ઓછા 2 વર્ષની સેવા બજાવી હોય ત્યારે બદલી કરી શકાય છે તેવી જોગવાઈ છે. પરંતુ જો પતિ પત્ની એક જ સ્થળે નજીકના સ્થળે રાખી શકાય તેમ હોવા કિસ્સામાં પુરુષ કર્મચારી 1 વર્ષની સેવા બજાવી હોય તો પણ 1 વર્ષ પણ તેમની બદલી ફી જિલ્લા ફી બદલી કરી શકાશે.
Yes, who appears for the state?
Page 25, the Lord Master.
Yes. He is relying on this, yeah.
Of the GR, please. The GR is on a completely different aspect, Your Lordship. The same paragraph which is read by my learned friend.
No, read the heading. Rajya Seva, Panchayat Seva.
Now the paragraph.
Where is he working?
He is working at Patan.
So state. So Rajya Jahir Soma Naukri Karti.
Here talks about the person who's there on the fixed salary, that person applying for transfer. If the lordship may kindly read it with me again, the lordship. What it says is, सामान्य वहीवट विभागના ઉપર પંચાયત ક્રમાંક 2 ના સામે ધરાવતી પેરા નંબર 2 is what I'm reading. ક્રમાંક 3 સામેના પરિપત્રથી દિવ્યાંગ કર્મચારી તેમજ કરાર આધારિત ફિક્સ પગારની નિમણૂક મેળવનાર મહિલા કર્મચારીએ ઓછામાં ઓછા 1 વર્ષની સેવા બજાવવી હોય, પુરુષ કર્મચારી ઓછામાં ઓછા 2 વર્ષની સેવા બજાવવી. આવા ઉમેદવારો જો બદલી માટે અરજી કરે, so if the husband applies for it, આવા ઉમેદવારો જો બદલી માટે કરે. Now here the question is page 19. Why page 19 order has been passed, which is issued before your lordship?
Wife has,
Things your lordship.
wife has applied.
So the GR is not applicable, your lordship. So our order is a good order. If a lordships may kindly have page 19.
But what difference does it make that if a husband
Lordship,
apply?
Lordships, here completely the parameters will change. Here-
What parameters? Husband and,
Show it, your
see
lordship,
the-
as far as I understand the practical difficulty what your lordships are referring to. But-
see the purpose, the intent of GR is to place him
Please, your
together.
lordships, please, your
Either
lordships,
wife applies or a husband applies.
please,
A
your
husband has a right of application. He can apply.
Please, your lordships, which he
Okay.
has not. It is here the wife who has applied under false declaration. That is why we said
It's
that
not
it
a
is false.
false
And you would
declaration.
not have done this.
તમે ક્યાં પ્લેસ કર્યા છે હવે? This is,
And sending them after the election.
હા, અને પછી હવે તાલુકો સાતલપુર, જિલ્લો તો પાટણ જ છે.
More than 255 kilometers far than that. More than 300 kilometers per day I have to travel.
You just stick instructions. This can't be done.
Just that the proper.
Issue notice.
Please,
You can't, government can't do like this.
There is still there is cost of vacancy also. There may be stay below, otherwise.
That-
it's very
That
difficult.
can't, transfer matter can't, there can't be any still, please.
Direct service.
Direct service.
Please.
Is there any right avenue open for the application to be made by husband?
As per the GR, it seems there is.
Yes.
Because they have
So
got
he,
for more
if
than
he,
3 years.
so but now like, is there any, where he has to move an application seeking transfer at any point?
To-
Or
to
there-
his department,
it-
to his parent department.
Ask petitioner's husband to make an application during pendency of petition.
My learned
True.
is different. Here,
Yes, that is true, but in during pendency, let him make an application.
Please, Aloj. We'll do it. Grateful.
Yes, chalo next.
Serial number 9, SC 10322 of 23, Mr. Vaidhi.
With respect to the regularization of service of the petitioner. So that was rejected by the respondent. I would like to point out the fact, 2009, pursuant to the approval NOC issued by the DEO, Banaskantha,
Hmm.
the advertisement was issued by the school.
Hmm.
Management wants to appoint one teacher for the pursuant to these, the present applicant along with other persons approach before the authority and file a form. After the consideration of the resolution of the government on 16/4/2005, the appointment order came to be issued in favor of the present petitioner. Now, Lordship may kindly see the first NOC issue by page 28.
Yes, please read.
NOC Babar, it was addressed to the Gujarath Gedavani Mandal, HV Chauhan. Then after Lordship these with certain conditions, subsequently this NOC, the advertisement was issued page 31.
This is NOC with regard to what?
This is the NOC for appointment of teacher. Lordship may kindly see page number 29.
Yes.
NOC ની વિગત શિક્ષણ સહાયક from number 1 These are the details mentioned. Shikshan Sahayak,
Yes,
then
yes, please.
Yeah.
Then
there is
report
the
to-
one vacancy available
Yes.
to them. With certain condition. Now, Lordship may kindly see after granting of NOC DEO, the presence response number 5 issue the advertisement page 31 for inviting the
Yes.
notification
Yes,
and the application. As per the circular of the government and page number 31.
yes,
The on 16/4/2005 that NOC the circular I have also annexed in page 32. Then after the present applicant made an application, that application is page 36.
yes, please.
Then after the Panch Rojkam was done, the committee was called the interview, the person was called for interview, and then after page 26, page number 42, this is the appointments order. After completion of the 5 years of service, the DEO wrote a letter to the state government to consider the case as a regularized, page number 44. (19/5/2004), after completion of the 5 years.
Yes,
It is in commissioner school. अनियमित नियमित करवा एवी परमार शिक्षण सहायक.
so recommendation was made by.
Recommendation was made. They have not considered. No reply is given. Second time recommendation was also made by DEO. Page number 45.
49, 40,
45.
45. Yes,
And the second time on 17/9/2014. Second time also. Then after they the authority did not consider. I filed a petition before this Honorable Court. This Honorable Court initially issue notice, and then page 47. This is the final order to make a representation to the authority for regularization of service. Now in that proceedings, page 48, there is the one affidavit, one order is passed by the Commissioner of School, whereby he says that in bottom para 3,
yes, please.
इंटरव्यू बाद जिल्हा शिक्षण अधिकारी बहाली मेळव्या शिवाय नियमुक नियम विरुद्ध 5/1/2009 ના પત્રથી સંચાલક મંડળ મંત્રીશ્રીની સહિતની ઉમેદવારીની શિક્ષણ સહાયક તરીકેની નિમણૂક કરવામાં આવે છે. મંડળને આપવામાં આવેલ એનઓસી ની શરત 15 તો શિક્ષણ વિભાગના 6/10/1998 ના ઠરાવ મુજબ નિમણૂક આપતા પૂર્વ જિલ્લા શિક્ષણની કામ ચલાઉ બહાલી મેળવવી આવશ્યક હતી. પરંતુ સંચાલક મંડળ દ્વારા નિમણૂકની કામ ચલાવી બહાલી કોઈપણ પ્રકારની રજૂઆત મંજૂરી પ્રક્રિયા હાથ ધર્યા સિવાય ઉમેદવારને સીધે સીધી રીતે નિમણૂક આપી દેવામાં આવે
So
છે.
there was no fault of him.
No fault of NOC was issued by the DEO. Advertisement was issued by me. I was appeared before the authority. Now, Lordship, after several years, I am in service. The person provided the service. Now, Lordship, there is a circular of the government. The minimum student, there is a teacher requirement. That circular is also I am annexed.
Yes, who appears for this court? You see, what is his fault? They were received.
The Bahali is the syllabus about. It is the purpose important because my lords, there are some parameters set up by the
But it is to be initiated by whom?
the school. Initially, they have to apply to the DEO that we want to appoint this.
No, but it's a DO's recommendation.
Yes.
It's DO's
That
recommendation.
is right.
So
Right.
then it is more, it is better than the school recommendation. It's not that school had forwarded the application and DO is not considered. It's a DO is considered.
I will.
Yes, notice.
I may take direct service.
The direct service. Yes,
Grateful to.
next.
Number 10 SC 1/5 of 23. I shall find it.
We are praying for the grant of higher pay scale. It is squarely covered by the judgment, which is at page number 11.
Notice. What's the good name, please? Please provide the chief.
Yes, sir.
And I put Miss so and so for Harshal Pandey. Yes, next.
Number 11 SC 1/5 of 23 of 23.
So that matter RPF to RPS with wherein Mr. Sayyid lead. Because he was your only the division bench matter that got called out, Manoj.
But
It can be
one
kept
more-
at 2:30 minutes.
No specific time, but it will be possible. Yes,
Public-
please next.
Public. Grateful.
Well, SCA 1/23, 9875.
Please, your ladyship.
Yes,
Here, my lords, the petitioner also seeks to appear in the intra-court camps which are to be organized. Now, my lords, the petitioner was declared surplus and he had filed a petition. Interim order is dated 27/5/2022, page 13,
1-3,
13.
yes.
The authorities were directed not to act upon the posting orders that were issued, para 5, page 14. Para 5, page 14.
Yes,
This is the direction given.
yes.
By virtue of this order, the petitioner came to be continued in the same school. Thereafter, my lords, the policy of transfer changed on 11/5/2023, and it further was amended by resolution dated 2/6/2023.
Page
Page
number
80.
80 of civil application.
Of the civil application, your ladyship.
See, if the policy changed, then you are not affected by the earlier policy, through which you came before this court and you asked for the interim relief. Now that policy is no more in existence because it is being substituted by new policy. Now the grievance does not survive. What is the question of keeping the petition
So,
pending?
So, my
So
lord,
that has created a problem.
so my your ladyship, if the posting order gets diluted, and since there is a vacancy in my school, if I am continued, there is no grievance. Now the problem is what happens, why do I have to come with this civil application is that because of the change in policy, they issued a letter dated 17/5/2023 for organizing camps. Your ladyship may kindly see page number 76.
So they have to act upon this policy.
I'm-
Policy is dated 2/6/2023.
I'm not even finding fault with it, your ladyship, but your ladyship may kindly see page number 76.
Yes, please.
17/5/2023 is the order, a letter issued by the Director of Primary Education.
Just a minute. Yes,
Now, your ladyship may kindly see clause number 9 of that very letter.
75.
75. Clause number 9 is at page number 78.
Yes, please.
May I read your ladyship? જો કોઈ જિલ્લામાં કોઈ પણ જગ્યા માટે નામદાર હાઈકોર્ટ દ્વારા વચગાળાના હુકુમથી જે તે જગ્યા ખાલી રાખવા માટે હુકુમ કરેલ હોય અને કેસરી આખરી ચુકાદા આવવાનું બાકી હોય તેવા કિસ્સામાં નામદાર હાઈકોર્ટના આદેશ અનુસાર કાર્યવાહી હાથ ધરવાની રહેશે જેથી હાઈકોર્ટના અપમાન પ્રશ્ન ઉપસ્થિત ન થાય. In my case, there is an interim relief not to act upon the posting order. That means I am continued in the same school. Now, your ladyship, because one teacher retired, there is vacancy in my school, and if the school vacancy report is seen, page number 91. Sorry, 92.
Page number
92.
92. Yes.
The
this is
first
the
school.
vacancy position.
Yes. So now they have shown vacancy in the very school where I am working. Now there is no vacancy because I am already there. Item 1. Sabarkantha Talod Simlia Primary School.
Page 90 you are reading.
92. 92. The very first school.
Yes, Sabarkantha Talod.
Simalia Primary School.
Huh.
One place is shown vacant. Now there is no vacancy because I am continued there. As per their clause 9, they should not have shown this because I am there. There was no reason for me to file this application if this was not shown. Now, since they have shown,
you want to continue here?
Yes,
Yes.
I am already continued. And now, because of the virtue of the resolution dated 2/6/2023, in the intra-district camp, I can participate. So I made an adventure to participate in the camp. but they are not accepting my application. So if I accept by the virtue of their own resolution,
So if you you are being permitted pursuant to the new policy to
Yes.
participate, then it would be violation of this court's direction.
no, your ladyship, the order of the
Order
court is not to issue any posting, not to act upon the posting order.
Then
But it does not say that I cannot participate in the camps. And just to avert any further complications, your ladyship, I had also given an undertaking on 9/6/2023, page number 95, that I will withdraw the petition. But they did not accept my application. I gave a undertaking on a stamp paper. Your ladyship may kindly see.
so therefore the crux of the matter is pursuant to the new policy, page number 80. Sorry,
yes,
new policy is page number 80.
80.
So now it is policy dated 2/6/2023.
Yes,
Pursuant to this policy, you can participate in inter-district camp.
yes,
Because of pendency of this petition, they are not accepting despite undertaking.
yes.
So you withdraw at this stage and you will be permitted to participate.
And your ladyship, I am
See, on one hand, you say that I want to retain at this place.
So your
at
ladyship,
Pata.
yes, so your ladyship, Simalia school, I am already working. Because the posting order is not acted upon, I am working. And as of now, there is no vacancy. But since they have shown vacancy.
Understood that
Now-
it's a mistake. They
Yes.
will clear it.
So
But
today,
with your regard to your main prayer that I am permitted to participate in the
Yes.
camp, pursuant new policy,
yes,
that you withdraw this petition because that will suffice. I'll
if
clarify.
my learned friend agrees,
Yes,
I'll
Mr.
also
Patel.
take instructions.
agree.
Because now lordship is to see the last page of the civil application. That is of 9/6/2023
Yes,
Yes.
and today is 26. Now what they have stated in that application, last particular 3 lines.
This is the undertaking which she gave?
yes,
And
yes.
then no. Furthermore, last 4 lines.
Yes.
So and so નામદાર ગુજરાત હાઈકોર્ટમાં દાખલ કરેલ પેશ લેવા બાબતે બાંહેધરી
હા.
જિલ્લા
પછી
શિક્ષણમાં રજૂ કરેલ છે. તે બાબતે આધાર અમારા સો એન સો ને આપવા જણાવે જેથી નામદાર ગુજરાત હાઈકોર્ટમાંથી અમારી કેસ વિડ્રો કરી શકાય. That is the 9/6.
Yes, yes.
26/6 they have not acted upon. Otherwise, what had happened, my lord? As per the schedule, if suppose there would be a vacancy and another person is entitled for the same and he or she applied, then immediately we have to give. But here the case is
what would be the date of application that has gone?
yes, that's why
Before 10th June.
yes.
10th June was the last.
Still it is there.
No,
10th June.
that has been
Then,
over.
so that has been over. Then
That's
what
why.
is-
Yes, so I applied, but they did not accept. I gave this undertaking. Hence this application, please accept my application. Since they did not accept for my original school.
What is the way out, Mr. Today?
Only I can say, if suppose the vacancy would be there and nobody has applied or accepted, then certainly. Otherwise, if support on, because this is online. Lordship please to the schedule that is on page number 83. That is a schedule, and as per schedule, that is we have to act upon.
No, but your ladyship, it is a mistake that they have shown this place. Because there is an order not to issue any posting order, and as per their own letter issued by the director of primary education, that you should ensure that there is no contempt of the court. So they should not have shown this post vacant. Why
We
did
have
they
shown
show
if
it?
suppose
But
the-
they have to correct their mistake.
No, they possibly their case would be that pursuant to new GRAs, you are eligible to appear in the intra-district camp, transfer camps. You have applied. They have accepted, they have not accepted, that is a secondary thing.
Yes,
But what is your prayer today? That you want to participate in the camp,
yes.
but you want assurance with regard to the.
That you
post.
will accept my,
I-
no, 1 minute, 1 minute. So the GR says that first preference in the original school will be given to a teacher whose original school it is. As per their own resolution, they have to give a preference to me. But they have not accepted my application. I will not, now he is saying if someone has not accepted, then it would be a double whammy for me. I will withdraw the petition. They will not accept. Where will I go? And today, your ladyship, for 1 moment, I am working in that school. There is no vacancy. Now, if they bring any other teacher, that teacher would be surplus. It is not helping anyone.
So again, a new round of litigation would come.
what had happened?
So they are creating complications. Right now, posting orders are not issued. If they permit and accept my application under the category of original school, naturally, I would get the benefit of selecting that school. Today, if I don't participate in the camp, because of the interim order that is passed by this honorable court, I will be continued. But if they accept my application form for the mother school, I will select that school and then I can withdraw the petition, your ladyship. One petition less for everyone.
Now, Lordship, please to see.
And it is very simple. I am entitled. If page number 80 can kindly be seen. GR dated 2/6/2020. Your ladyship may kindly turn the page. 81. Modified clause I will read.
Yes.
વધઘટ બદલી કેમ્પના હુકુમ.
પછીના
પછીના વધઘટ કેમ્પ તથા જિલ્લા આંતરિક માંગણી બદલે કેમ્પ સહિત કુલ 5 કેમ્પમાં મૂળ શાળામાં પ્રથમ ખાલી જગ્યા ઊભી થાય ત્યારે વિદ્યાસહાયક શિક્ષક પોતાના વિભાગના વિષયની ચોખ્ખી ખાલી જગ્યા પર મૂળ શાળામાં તેઓ પોતે જવા ઈચ્છે તો જવાની પ્રથમ તક આપવાની રહેશે. First preference is to be given to me. જો મૂળ શાળામાં પરત જવાની તકનો અસ્વીકાર કરે તો મૂળ શાળામાં પરત લાભ ફરી ક્યારેય આપી શકાશે નહીં. ત્યારબાદ વધ કેમ્પની અન્ય કાર્યવાહી શરૂ કરવાની રહેશે. So that means first
Mr. Patel permit petitioner to participate.
Certainly, my lord, but here first of all,
with the undertaking.
because if suppose the undertaking has been filed,
See, that is whatever your decision, she has the right of check.
lordship,
So
lordship,
at this moment, permit
Please,
for,
because the order to be issued by the office of the director primary education as per
civil
the schedule.
application number 1 of 2023 and SCA number 9875/2022. This civil application is filed. To with the following grievance. Latin Action 1 AB CD CD page number 10. Unlearned Ms. Vidhi Bhatt for the petitioner, she submitted that pursuant to the new what is intra-district transfer policy?
Yes,
Intra-district.
it is transfer policy.
It is a pursuant to new transfer, pursuant to the transfer policy dated 2/6/2023. The petitioner is eligible to participate in the transfer camp and is eligible for the priority to be given in the mother original school. Full stop. Despite that, the application filed by the applicant to participate in transfer camp pursuant to new policy dated 2/6/2023 has not been accepted, which has caused prejudice to her. She is admitted that even otherwise also, as per directions of this court dated 27/5/2022, the petitioner is to be retained at mother school and no posting orders no transfer orders either.
Transfer orders.
No transfer orders are to be effected in case of the applicant. Applicant લખજો બધે ફૂલમાં petitioner. હા. She submitted that even the undertaking to the effect. What is your undertaking?
Page 90.
Page 95.
Yes. Undertaking to the effect that if the petitioner is given a preference to retain him in mother school, he would withdraw the petition. The said undertaking is made before
The district
district primary education officer Despite that, no action is taken and the applicant is permitted to participate. What is our
My
permission?
contention would be there. If suppose first lordship place to the page number 83. The
83.
particular schedule has been given, okay, when to be applied and what to do. Page 83. That is for Pratham Tabakku.
Then that tabaka is gone. That's what you're,
That's why if suppose that has been over, we can't do anything.
yes.
But-
Opposing the application, Mr. Patel submitted that
First,
is dated any?
yes, page number 83, first, that is of
That is-
June, Badli camp, June
The
2020.
the stages of transfer camp, schedule of stages of transfer camp has already been published. And if the transfers are effected as per the
Then we
schedule,
can consider for next
Ah.
if vacancy.
then the application of the applicant would be difficult to consider despite he having eligible to apply pursuant to the policy dated 6/26/2023. Consider the submission. From the policy dated 2/6/2023, the applicant is eligible to participate in the transfer camp. Only hurdle which is faced by the respondent is in relation to the schedule which has been published and any procedure. What you say that that these are the stages or any
These are
stages?
There are different rounds. If suppose that is the first round.
Any rounds which are over and the transfers are effected. Full stop. It is not the case of respondent that the applicant is not eligible to participate in the case. Even otherwise also, this court under order dated 27/5/2022 has directed the respondent not to effect transfer in case of applicant. Considering the submission, the respondents are directed to accept the application of the applicant, accept the application of the applicant which is made pursuant to policy dated 6/26/2023 and consider the same.
Your ladyship, may kindly see 21A prayer, 21A, page 10.
That I can't direct them to give you the posting if they and to consider the same.
Under the category of original school. If your ladyship may just.
In accordance with the law, particularly the policy dated 11/5/2020.
2/6/2020.
No. Sir, you have to be retained in the, you can ask for the parent school is
2/6/2020.
as for the new policy. With the above direction, the civil application stands is disposed of.
I'll take direct service.
Direct service permit.
Okay. Your ladyship, may I request for direct service today because
We'll get it.
obliged.
તમે કોઈને બોલાવો મધુબેન અમને 2-3 ડાયરેક્ટ સર્વિસ ટુડે જ કોલ સબન કેટલી વાર છે તમારી કોણ બીજા હા તો રે આવશે પહેલા ડાયરેક્ટ સર્વિસ આવે
Obliged. Daily board, serial number 1MC, 1 of 2 between SC, 18104121.
Okay, for non-removal of office objection એવું છે? કોનો કોડ છે નીચે?
Please get for 230. Number 4. So you want to proceed.
જો આ application under objection આવે છે. Let's pass over for something. Yes, please.
Lordship, Mr. Shalin Mehta appears for the respondent. May request for a pass over.
Serial number?
4.
4. What's the issue?
But the honorable court directed them or permitted them to operate the wait list in accordance with the law. While reading this affidavit, I came to know for the first time, kindly see the order.
Only just.
I'll wait for Mr. Mehta, no difficulty.
This is the
Page-
reminder.
This is my reply to the civil application that is filed.
The order which is passed by this honorable court is reproduced on page 30. But as I understand, my challenge is to the preparation of the wait list that is not in accordance with the law. That is Nirav Makwana and other judgments. The application was preferred for the purpose of permitting them to operate the wait list. Priority was sought. My contention was that it is not prepared in accordance with law and the rules, as the case may be.
The
The
wait list.
honorable court permitted them to operate the list. Now kindly oblige me by reading the last sentence on page 31
Of the civil application.
of
you
the
are
civil
talking?
application.
Yes, please.
My reply. Right, CA, the order is already there. The honorable court may kindly have a look
This
at
is the
page
reply
11.
which has been given.
Page 11 or 12. Page 12 may be seen of this application.
No, the page you are referring to, reply page?
Page 30 and 31.
Yes, please.
Reading the order dated 20 September 2022 does not refer to keep any post
Just a
vacant.
minute, please read it in entirety so that at
No,
least.
I follow. I'll read that.
Appearing for respond number 4 to 20, private investors. Oh,
Priority sought by learned senior
yes,
advocate.
non-operating will cause prejudice. Then what?
This was their case. My
Yes.
case was that the list is not prepared in accordance with law. That is what is recorded.
Yes.
The honorable court, after taking into consideration the concession made by Ms. Baya that we would operate the list in accordance with law, I'll read that. Learned advocate Ms. Baya, appearing for the respondent, submitted that they are operating the wait list and issuing appointment orders as per government resolution dated so and so. She further submitted that GPSC, being government agency, is bound to follow the government resolutions and conditions stipulated therein. Role of the GPSC is to conduct the examination and make recommendations. They have prepared the wait list as per government resolution for the posts which are subject matter of the present petition. Perusal of the said list provides the separate list for each category has been prepared based on merit each candidate possesses. This I have already argued that it has to be a continuous list, not each category. The honorable court had a detailed or had an opportunity to give me opportunity to assist that it has to be a continuous list, but I'm not on that right now. It is noticed that this court issued notice under order dated 8 July 22. Thereafter, civil application was filed by the petitioner with a prayer to keep 2 posts vacant for sales tax inspector class 3 during the pendency and final disposal of the petition. Coordinate bench of this court in civil application passed the following order. To be placed with the main matter, appointments, if any, shall be subject to further orders. Reading of the above order dated 20 September 22 does not refer to keep any post vacant or not to operate waitlist prepared by respondent number 3 GPSC. At this stage, it has been pointed out by learned advocate Ms. Baya that there is no challenge to the government resolution dated so and so. In view of the above, it is open for the respondent number 3 GPSC to operate the waitlist prepared in accordance with extant rules and law. It rejects my petition. This is the challenge in the petition. The honorable court permitted them to operate the list in accordance with extant law and.
But you say it is not on extent, as per the extent rule and law.
Correct.
That is your case.
That is my case. Now, petition is yet
So
to be
you-
decided.
that-
Correct.
your extent rules are correct or his
Correct.
rule
Now,
is correct. That
this-
is a matter of interpretation.
That is right. Now the honorable court may kindly have a finding. This is the finding recorded in this this application, 1 of 23, that the list is prepared in accordance with extant rules and law. It actually rejects my petition. The challenge still survives.
See, as per, see, very clear. He says that we have to go by the resolution dated 27/7/2018, and as per their, as per the interpretation which is 27/7/2018 pertain, they prepared a wait list.
Correct.
It is their case.
It is their
You
case.
say that 27 is not to be applied, some 25th is to be applied. Resolution of some other date is to be applied.
Interpretation of 27 July is also in dispute.
Then where is the challenge? There is no challenge to 27/7.
Kindly see. My contention is that the list is not prepared in accordance with even that resolution.
Then any other petition would lie, you challenge that 27/7.
My respectful submission is
Change the, now you can't mold the relief by.
I'm not requesting the honorable court. I'm only pointing out that by passing this order, my petition gets rejected.
Let's see your prayer.
Please, Lord.
Not to interrupt my learned senior, but may I request that the matter be passed over, let Mr. Mehta be here.
It's a pass over person. See that I think order is very clear that it is they who interpreted 27/5/2021 as per their interpretation, they have to operate the wet list. There is no challenge to 27/7. This court said they should operate the wet list. If you are agreed by 27.
Wait matter is also coming up on 30th.
By that time, appointments are made, my petition would become infructuous.
Then you challenge Mr. Joshi. See, the order itself is very clear that if you are not in agreement with the wet list which has been prepared by them, if they say it is 27/5/2018.
I'll take the instructions in the meanwhile whether to challenge this order or not.
Yes.
Let it be kept at 2:30 so that
This order you can challenge.
I
Civil
follow.
application order.
I follow.
Yes, that is the easiest way. Yes.
Maybe kept at 2:30 so that we come at a particular time, please.
Bill number 5, SCA 1309 of 22, Mr. MS Padaria.
Sure.
Bill number 6, CA 1 of 23, SCA 1796 of 22, Mr. JP Parmar.
Who wants who?
Yeah, for
Why you want to join?
executive engineer belongs because of the leave encashment which not given by the authority. therefore.
Yes, allowed. Joining application.
Mainly on 5th Milo.
Main matter of 5th
5th
of August.
5th September.
July.
July, sorry. 5th July.
Ito,
Okay.
civil application is disposed of.
Okay,
You need to amend the cost
Yes,
structure.
yes.
Within a period of 1 week, huh?
Much.
Yes.
Bill number 7, CA 1 of 23, SCA 19961 of 22, Mr. JP.
Civil application disposed of, allowed, disposed of as allowed, is to carry out necessary amendment in the cost title is to be done within a period of 1 week. Yes. Next.
Bill number 7.
Sure.
Bill number 8, MC 1 of 23, SCA.
8 and 10.
8 and 10,
Please, madam.
the identical order. are-
Same order.
Why you gave an on that day some wrong order?
Because on that day there is a bunch of
But therefore, I'm like telling you everyone that whenever you are passing the earlier order, you please refer that serial number and the SCA number of the board. Otherwise, no orders will be passed. Even no notice will be issued without that serial number and special civil application.
The two matters.
One-
8 and 10.
8 and 10.
direct service.
Direct service permission. Where is the order? Where are the orders you have given?
That is one of the matters this issue had arisen, my lord, that the parties were SSNL. Now for accessible, my lord, there is an entire different set of regulations.
So this is in relation to,
Length of service.
that is true. But then review is to be allowed for, recall is to be allowed for.
Yes, that is.
Where is that order? Yes, please. This is recall allowed. Number multiple, 8 and 10.
Prayer are they pressing?
Sorry?
The memo does not contain as to what prayer are they pressing instead of what.
The prayer only says that review and recall, that is it.
So that
What is
has
to be substituted is not there.
in the.
Show me.
Again, give an-
Prayer in recall application?
Yes. Page 7. Paragraph 4B.
Peace to place appropriate orders, but that must be there in the grounds. Let's see. Nothing?
You'll have to amend it.
Incorporate and reproduce that particular prayer asked for in the. Today, what he asking for review is not.
See, turn to page 8. However, by mistake or typographical error, the prayers made in the petition which covered by apex court judgment issued.
Pass the appropriate orders.
Presentation was about not making a full payment of penalty benefit from the initial even appointment, leave pension and other benefits, including the use of statute. However, by mistake or typographic error, the prayers made in the petition which covered by apex court judgment as well as there is no more repetitive in view of the said decision, and therefore the order dated so and so passed in SC so and so is required to be reviewed in the legal justice. What?
And appropriate order is be passed.
The issue is that only thing it will again, subject matter and prayer of present petition was about not making the full payment of pension. That's what his relief is.
Where is the legal?
Yes, you please amend the petition by incorporating only this where that what you want, that petition full payment of pension benefit from so and
Please,
so. At 2:30, will you be able to?
Please, madam.
You have to first recall it and then you have to. He has not
That's-
mentioned that in his prayer.
I think there are 2 applications which are filed. બંનેમાં review જ કરી છે તમારી recall ની કોઈ application see there are 2 application which are I want because therefore I asked. First is review oblique recall. Let it be. Amend the petition. કાલે રાખો હતું.
Please, madam.
બંને ના અમારા ભાગો. Amend the petition. Prayer clause. Next.
Number 9, there is note of Mr. Daviji Mulla. Number 10, orders are passed. 11, SCA 4796 of 23, Mr. Shilajit Pillai.
Yes, ma'am, I appear with Mr. Pillai. This is matter for admission, wherein the award of the labor court is challenged by the workman. Slight facts before I take to the award, my lord. The workman came to be appointed as a ward boy in a hospital in Bhavnagar. That was in the year 1983. He was continued in service from 1983 till 1991.
Yes.
The hospital is Sir Takhat Singh Ji Hospital at Vadodara. 83 is the appointment, continued till 91. Subsequently, in 91, he came to be removed from service by an oral order. Nothing in writing. As a ward boy, his services were continued. He worked there for around 8 years.
Where do I get is that he's continued from 83? Where is the first order?
The first order, actually, in fact, the appointment order which was placed, that is of 84. If the Honorable Court may be kind enough to turn to page number 35 onwards, but relevant would be 36.
Why 35 is not?
What had happened that when we approached the labor court, again the query came that show your appointment order, how are you terminated? So we had put on record the Praman Patra by the district TB officer Bhavnagar, which said, if I am permitted to read page 35, the typed copy is at 35A. આથી પ્રમાણપત્ર લખી આપવામાં આવે છે કે શ્રી રાજેન્દ્ર તુલસીભાઈ બારડ, જિલ્લા કેન્દ્ર ભાવનગર ખાતે વોર્ડ સર્વન્ટ તરીકે હંગામી સર્વિસ દરમિયાન ખંતપૂર્વક સંતોષપૂર્વક સેવા બજાવેલ છે તે બદલ આ પ્રમાણપત્ર. So appointment order was not there. So we only showed that, look, we have a certificate that we were having satisfactory.
It was.
So that happened, that the Honorable Court will find at page 36.
Yes, please read.
If I am permitted to read, તારીખ 12/1/1986.
Yes, please.
પતિ શ્રી બારડ રાજેન્દ્ર તુલસીભાઈ, વડવા તલાવડી મુજબ ગેરેજ પાસે ભાવનગર. આથી તમોને જાણ કરવામાં આવે છે કે વર્ગ 4 ની જગ્યા સર ટી તખતસિંહ હોસ્પિટલ ભાવનગરમાં ખાલી પડેલ વર્ગ 4 ની જગ્યા માટેની ઇન્ટરવ્યુ તારીખ 17/1/86
Yes,
ને શુક્રવારે.
Yes.
So this is very, and he was appointed, that is on the next page, from 17/1/86. The case is that in 2091, I came to be removed from service. I approached the conciliation officer. Conciliations took place. In the interregnum in 94-95, similarly situated people who were also earlier removed were taken back on service, which I put before the labor court. Labor court did not, so the entire reference was moved in the year 96 onwards, which concluded last year. The award is ordered at page 18. The final order is given wherein the labor court says, or rather neglects my argument that I was in continued service for 5-6 years. Others like me were settled. They were taken back in service. I was not. A long time has passed by. Even my cross-examination was done, wherein I have also stated that now today there can be no reinstatement.
What are the errors? How why you say that this order is erroneous?
The
Oral evidence has not been considered.
it has been considered to that effect that when we say that we were in service, they are saying that no, you are not in service. The argument
evidence
is
to be led by you. It is
the-
whose onus?
there was on us. It was definitely on us. We did our best.
In
There
that
are-
context, please read that order.
You may be kind enough to turn to page 24 onwards. If I may read from below, para 5, J. Sandarbhe, page 24 of the award.
27, they have framed the issues and thereafter
Please.
they have started with the.
But
findings.
the arguments which took place, I have been able to substantiate my argument that, sir, I not only worked with the institute, but also they have reappointed similarly people, but not me. And termination was illegal because per se it was an oral order, not even a written order. My appointment order is there. So had I to be removed from service, something in writing should have been given at least. I have proven my bona fide by saying, look, I have got a satisfactory certificate. I was working as per
Turn to
their
page
satisfaction.
31, straightway.
Please.
Please, page 30. Page
Page
30.
30. Paragraph 9 onwards. અરજદાર દ્વારા સદર કામે સામેવાળા નંબર 1 દ્વારા તારીખ 20/11/94 ના રોજ મજૂર અદાલતમાં સમાધાન કરેલ હોય અને તે સંદર્ભની જે પણ કોઈ હકીકત જણાવેલ છે તે સંદર્ભે સદર કામે જોએ તો અરજદાર તરફે નિશાની 31/1 થી તથા સામેવાળા નંબર 1 નાવે આંક 39 ની રેફરન્સ LCB નંબર 700 તથા અન્યના કામે થયેલ કોમન અવોર્ડ રજૂ રાખેલ હોય. જે અવોર્ડ જોતા તેમાં કોઈ જગ્યાએ અરજદારનું નામોનો ઉલ્લેખ હોય કે તે અવોર્ડ મુજબ સામેલ. Now I just pause here for a moment. This I had put to show that people similarly to me had settled with the institute and they were taken back in service. My grievance was that they did not do it with me. That is why how my name is not going to be there. That was my precise grievance, that they have taken others back in service and not me. નંબર 1 કે ત્યાં કામ કરતા તમામ કામદારો સંદર્ભે જનરલ સમાધાન થયેલ હોય અને તે મુજબ અવોર્ડ કરેલ હોય તેવું જણાય આવતું નથી. તેમજ ખરેખર તે અવોર્ડમાં જણાવેલ અરજદારો પૈકી કોઈ હાલના અરજદાર સાથે કામ કરતા હતા કે કેમ તે સંદર્ભે કોઈને સાક્ષી તરીકે
That is the
તપાસેલ હોય.
crux. It is you who ought to have said that you failed in every aspect. પછી તેમ આગળ વાંચો તેમ રેફરન્સ કેસ નંબર 100 કોઈ પણ અરજદાર ખરેખર હાલના રેફરન્સ કેસ ના કામ તેમ કોઈ હકીકત સામાવાળા
So far as this is concerned, in my cross, I have stated so. If the Honorable Court may be kind enough to turn to page number 25 for a moment. 25, where I have given names of people who are working with me.
25.
Page 25. If I may just read this two paragraphs. Paragraph 6 onwards. સદર કામ દલીલ ઉપર આવતા અરજદાર તરફે વિદ્વાન તરફે પ્રતિનિધિ દ્વારા તેની મૌખિક દલીલમાં જણાવવામાં આવે છે કે અરજદાર દ્વારા સામેવાળાને ત્યાં સન 1983 થી સન 1991 સુધી સળંગ નોકરી કરેલ હોય અને સામેવાળા દ્વારા અરજદારને આઈડી એક્ટની જોગવાઈઓ પાલન કર્યા વગર ગેરકાયદેસર રીતે છૂટા કરી દીધેલ છે. સામેવાળા દ્વારા આંક 6 અન્વયે થયેલ હુકમ મુજબના કોઈ દસ્તાવેજો સદર કામે રજૂ રાખેલ.
Page 31 again to go to.
પ્લીઝ I'll continue for a stop.
Yes.
તે રેકોર્ડ જતા જણાવવામાં આવતું નથી. તેમજ રેફરન્સ કેસ નંબર 1987 તથા અન્યના કામના અરજદારો પૈકીના કોઈ પણ અરજદાર ખરેખર હાલના રેફરન્સ કેસમાં અરજદાર સાથે કામ કરતા હતા કે કેમ તે સંદર્ભના કોઈ હકીકત સામેવાળા તરફે
No,
તપાસેલ.
page 31 નું second paragraph, second portion.
Please.
અરજદાર તરફે કાગે 41 થી
તરફે 41 થી સામેવાળા નંબર 1 ને જે પત્ર રજૂ રાખેલ છે જેમાં અરજદારનું નામ પ્રતીક્ષા યાદીમાં રાખેલ હોય અને તેના ક્રમ પ્રમાણે નિમણૂક કરવામાં આવશે તેમ સ્પષ્ટ જણાવેલ છે. પરંતુ ત્યારબાદ ખરેખર સામેવાળા નંબર 1 દ્વારા અરજદારને 6 માસની અંદર નિમણૂક આપી દીધેલ કે કેમ તે સંદર્ભે અરજદારે તરફે કોઈ હકીકત જણાવેલ હોય. Now I stop here for a moment.
Where 41 is to be placed
Please,
on record.
I will show that.
41, please. Exhibit 41.
Please, ma'am, and even
I think
36.
that last time 41 was called for.
First time.
This is arguing for the first time. The last time only HM. But at page 36, I have put that order. If the later part may be seen, that आज तारीख 17/1, I am reading the type copy 36B. આજે તારીખ 17/1/86 ના રોજ લેવાયેલ ઇન્ટરવ્યુમાં પસંદગી કમિટીને તમોને વર્ગ 4 ના કર્મચારી માટે તમો પસંદગી પામેલ છો અને તમારું નામ પ્રતીક્ષા યાદીમાં આજના તારીખથી 6 માસ માટે રાખવામાં આવેલ છે. પસંદગી ક્રમાંક તમારો નંબર 7 છે. હવે ખાલી પડતી જગ્યા ઉપર તમારા ક્રમ પ્રમાણે તમને નિમણૂક કરવામાં આવશે. So we said that this is the order which was given to us. Now the Honorable Court referring to
That
page.
was not pursuant to that some
That was to
settlement.
No, that was pursuant to one recruitment which
Do
they
you
put
have
there.
41 exhibit?
Exhibit.
What is 41?
41 पड़े थे यार. हाँ 31. ये जो आंक है ना इसका आंक 41.
Get that, Mr. Jadeja.
Please, I will put it by way of an amendment. Please. 41. I'll give me 2 weeks time. Please.
August. August.
Please. Oblige.
Serial number 12 SCA 7205 of 23 Germany 40.
Lordship, here applicant is given
recruitment in Lok Rakshak Dal. My lord, advertisement is annexed on Annexer A, 13, page number.
Yes, please go ahead.
Lordship, then after all exam is clear by the applicant, oral and interview and physical examination also passed. And my lord, then after kindly see page number 35, he is selected in this exam also. He is also come in merits, page number 36. Then after my lord, when they call for the selection of place, page number 37A, authority declined to give a recruitment because criminal case is pending against the present applicant.
Yes.
They given only oral instruction. He is not given recruitment because criminal case is pending against the present applicant. FIR is annexed on page number 41.
Page 37 is what?
37 is the merits list.
By those who are given appointments.
Lordship, Pasandgi Pamel bin Hathiari
Yes.
Purus Mahila
Page
Law.
38 is what? Then it is not in relation to you. You were
Lord-
not, you are not placing part in page 37 of the
Lordship,
selected candidate.
Lordship.
Yes, FIR.
FIR is page on 41.
Yes, please.
It is against the present applicant, my lord. In the FIR, accused number 4, offense under section 323, 332, 353.
What is your case?
My lord, it is fully covered by the Avtar Singh judgment, my lord. It is annexed on page number 46.
Yes, who appears?
Lordships, as far as the low craft is concerned, the entire procedure happens that way. And at the time of filing of the application copy is already
Wrong information has been provided?
not
No.
wrong information.
Then-
Because here at the time of application, the question itself is not asked whether there is a criminal case pending
Yes.
or not.
No.
The entire process takes place at the time of getting the certificate, the character certificate, a checkup, police verification takes place, when we come to know whether any criminal case is pending or not. If at that point of time, if it is found that a criminal case is pending, and a criminal case also, the type of criminal case is also considered. If a lordships may kindly have the FIR which is there
Yes.
against the petition. It is not only heard, it is being part of an unlawful assembly which hindered the police personnel from arresting 2 people. The lordships may kindly have page 41. The copy of the FIR.
Yes.
These sections are 143, 147, 148, 149, which is being part of the unlawful assembly. Then there is 323, 332, heard. Next page, page 42. Accused number 4 is the present petitioner, your lord.
Yes.
On page 43, column number 12 is already reading. આ કામની હકીકત એવી છે કે લાંગડા પોલીસ સ્ટેશનના સો એન્ડ સોના ગંભીર ગુનાના નાસ્તા ફેરતા આરોપી સો એન્ડ સો ની ગુનાના કામે ધરપકડ કરવાની હોય, બંને પોતાની ધરપકડ ટાળવા સારું આ બંને આરોપીઓ અને ઉક્ત આરોપીઓએ ધરપકડનો પ્રતિકાર અવરોધ કરી તેઓને ભગાડવા એક
Understood. They are of a serious nature. That's what you say.
Please,
What does Avtar Singh judgment
Avtar
say?
Singh is rather in my favor. If my
Yes.
learned friend is relying on it, it is there.
Page number, paragraph number.
Please, it is even reproduced in the petition itself on page 5, your lordships. The case of my learned friend is, first of all, that I have declared that there is a criminal case pending. But there is no such declaration at any point of time which is coming up on record. It is only upon police verification that we come to know that there is a criminal case pending. Now, the guidelines as far as criminal case is pending, as far as the Lok Rakshak recruitment is concerned. We even consider that સામાન્ય પ્રકારના ગુનો, let me just read. અત્રેની કચેરીને એવું ધ્યાનમાં આવેલ છે that વિષય is લોક રક્ષક તરીકે નિમણૂક આપવા બાબત. અત્રેની કચેરીને એવું ધ્યાન પર આવેલ છે ઉમેદવાર વિરુદ્ધ દાખલ સામાન્ય પ્રકારના ગુનાસર નિમણૂક આપવાનો ઇનકાર જે યોગ્ય નથી. ખરેખર ગુજરાત પોલીસ મેન્યુઅલ સ્વયંસેના માર્ગદર્શક સિદ્ધાંતો ધ્યાનમાં રાખીને ઉમેદવાર વિરુદ્ધ દાખલ થયેલ ગુનાના તમામ પાસાઓ, ગુનાના સંજોગો, ગુનાની ગંભીરતાઓ, સંબંધિત ઉમેદવારે ખરેખર ભજવેલ ભાગ એવી તમામ બાબતો પુખ્ત વિચારણા સમીક્ષા કર્યા બાદ જ આખી નિર્ણય લેવાનો હોય છે. I may read this again. ગુજરાત પોલીસ મેન્યુઅલ ભાગેના સ્વયંસેના આ બાબતથી નિશંકપણે પ્રસ્તાવિત થાય છે કે જે ગુના ક્ષેત્રમાં નૈતિક અધપતન, અસામાજિક વૃત્તિ, વલણના તત્વો જણાતા ના હોય તેવી બાબત અંગે પસંદગી પામેલ ઉમેદવાર વિરુદ્ધ કોઈ ફોજદારી ગુનો પડતો હોય તો તેવા ગુનાની ચકાસણી કરી જેમાં નૈતિક અધિપતન કે અસામાજિક વૃત્તિ, વલણના તો જ તેમની નિમણૂક નકારવાની રહેશે. The case in question is not that a matrimonial case is pending or some such case is pending. What is the case against the petitioner? Was part of an unlawful assembly which deterred the police personnel from arresting two serious offenders.
Just which paragraph you are relying of the thing?
Lordship, paragraph number 38.1, 38.2 in my petition also mention my.
Is the 30 para. It ends at 30.
Lordship, may kindly have page 5 of the petition.
But let me.
Because she has quoted it there.
But which, just get which paragraph she.
Please, Lordship, that 38.1
Yes,
is also there on page 5 of the petition. This is what my one.
No, just from this, where do I get? From the judgment itself. It is to be read in context with.
Please, Lordship. Rather, I will be relying on this judgment.
Which para are you relying? Internal page? Yes, internal page. Which page of the judgment are you relying?
Here it would be para 30, Lordship, page 70 if Lordship.
Yes.
We have noticed various decisions. On para
just
70, the very last paragraph. 70.
Okay.
Yes.
Yes.
We have noticed various decisions and try to explain and reconcile them as far as possible. In view of the opposite discussion, we summarize our conclusion thus. Number 1 is information given to the employer by a candidate as to conviction, acquittal or arrest or pendency of a criminal case, whether before or after entering into the service, must be true and there should be no suppression or false mention of required information. While passing the order of termination of services or cancellation of candidature for giving false information, the employer may take notice of the special circumstances of the case, if any, while giving such information. The employer shall take into consideration the government orders, instructions, rules applicable to the employee at the time of taking the decision. In case there is suppression or false information involved in a criminal case, where conviction or acquittal had already been recorded before filing of the application or verification form, such fact later comes to the knowledge of the employer, any of the following recourse appropriate to the case may be adopted. In a case trivial in nature, in which conviction had been recorded, such as shouting slogans at young age or a petty offense, which if disclosed.
Then next.
Please, Your Lordship. Where conviction has been recorded in a case which is not trivial in nature, employer may cancel candidature or terminate services of the employee. If I'll just stop here because there's no question of acquittal or conviction. Then the later discussion is about acquittal or conviction. The criminal case is pending. So the question of false declaration does not arise because there was no
It's
declaration.
you say it's not trivial in nature.
It is
That
not
is
trivial in nature.
your case only rests on that it is not trivial in
It is not,
nature.
and we are following our circular, wherein we consider those cases.
Circular can't go beyond decision of Supreme Court.
Judgment is given.
Because see, it is after all a law of the land, so you can't.
The person wants to join in the police force. He wants to be a lok rakshak. And the FIR which is pending against the petitioner is with respect to not allowing police personnel to do their job. This is, I would rather rely on page 71, wherein I've just read
Yes.
that where the conviction
I'm
has
not
been recorded in a case.
My lord, kindly say in the FIR, there is a no any single allegation against the present applicant. There is a common allegation, my lord.
But
My lord,
Unlawful
My lord,
assembly means what?
For that, my
Part
lord,
of unlawful assembly would means what?
my lord, if my lord, there is other co-accused are not a relative of present applicant, my lord.
But that is a matter
lord,
of adjudication. That is altogether that will take care of so far as the criminal prosecution is concerned. As and when the charge sheet file.
My lord, the charge sheet is filed, my lord. Trial
Then
is
it
committed,
is all
my
the more
lord.
strong reason
My lord,
not to intervene. Yes, please.
lordship, my lord.
Now you just summarize your submissions, what you want to contain.
Lordship, in the judgment, my
I'm
lord.
not inclined. If you want to withdraw, you withdraw at this stage. Once I dictate, I'll not permit you to withdraw.
Lordship, I'm not inviting the any order, my lord. I permit to withdraw. My
Mr. Learned Advocate Mr. Janani Patel for the petitioner seeks permission to withdraw the petition. Permission paid for is granted. Stands disposed of as withdrawn. Yes, next. SCA 7439 of 20, Mr. Indian Modi.
My lord, the application of workman compensation has been filed by the present petitioner, that is workman, my lord, that he got the injury during the employment. That application, WC application, was dismissed for default, my lord, against which my lord restoration was filed. The same was also not considered by the commissioner, my lord.
Why?
My lord, as such, if we go by the date, my lord,
You did not remain present.
in earlier, my lord, that issues, if my lord may just pay 13.
Yes.
Well, it is an injury case. There is no reason for the non-remaining present. Yes.
13 para 2.
Para-
કામના પક્ષકારો
આ કામના પક્ષકારોને આંખ સાથે નોટિસ કાઢેલી જે નોટિસો બચી ગયેલ હોવાનું 8-9 પોસ્ટલ ફલિત થાય છે. સર્વ નંબર 11 થી 2 તરફ એલ કલાનું વકીલાત રજૂ થયેલ છે. 8-13 થી લેખિત જવાબ છે, તેમાં પેરાવાઇસ ઇનકાર કરેલ છે. 14 થી સર્વ નંબર 1 નો લેખિત જવાબ રજૂ છે, તેમાં અરજદારની અરજીનો પેરાવાઇસ ઇનકાર. ધ્યાન માય લોર્ડ, આ કામે 8-15 થી 4/2/19 ના રોજ મુદ્દા મુકરર કરવામાં આવેલા છે. આ કામે મુદ્દા મુકરર થયા બાદ આ કામ પુરાવા પર રાખવામાં આવેલ. સદર કેસનું રોજકામ જોતા આ કેસમાં 4/2/19 ના રોજ મુદ્દા મુકરર થયા બાદ અરજદારને આ દિન સુધી પુરાવો રજૂ કરવાની તક મળેલ છે.
2004 to 2019 to 2/11/2021.
My lord, it is up to 2019. The issues were framed.
Yes.
After that, evidence stage of evidence has been started, my lord.
So અરજદારને આજ દિન સુધી
Yes.
પુરાની તેમ છતાં હાજર રહેલ નથી કે પુરાવો રજૂ કર્યો
Yeah,
છે?
my lord, may consider that after in the year 2020 and 2021 there is a corona, my lord, and in 21, my lord, the case has been dismissed for default. Well, it is a compensation case. There is no reason for me to not remaining present intentionally, my lord. So, and my lord, there is a workman compensation can be considered in a very liberal manner, my lord, because it is not. It is, my lord, he got the accident, and my lord, it is for the compensation, my lord. No similar identical issue, fact, my lord, this honorable court has considered such type of thing, my lord, liberally. I'm sorry, it is, my lord, there is some pencil mark is there. This is the copy wherein pencil mark, para 6, my lord. As such, my lord, it is not to be prejudiced to other side, my lord. If I got the opportunity, it will not cause prejudice, my lord. Well, it is also, my lord, workman compensation application was dismissed for default. Restoration was filed. Restoration was also dismissed on the ground of non.
Who,
It is a fresh matter.
that is who is the opponent? Notice for final disposal is required, or do I?
Yes, my lord. My lord, in my resource submission, government is not there. It is a private parties and insurance company is there. So
Notice is required to be.
notice is required to be.
Notice for final disposal. You look on, so how long has been Mr. Hiren Modi for the petitioner? He submitted that the application of petitioner seeking compensation under
Employees Compensation Act,
Employees Compensation Act has been rejected,
dismissed for default.
dismissed for default on account of non-prosecution. Full stop. He submitted that there was no intention on part of petitioner not to remain present and lead evidence. Despite that, on account of
Within 10 days, the restoration was filed.
on
After-
account of COVID-19 pandemic in the year 2020-21, the petitioner or his legal representative could not remain present to lead the evidence. And therefore, the order dated 2/11/2021 deserves to be paused and set aside.
Well,
He submitted that no prejudice. It not caused and set aside is erroneous. He submitted that no prejudice shall be caused to the respondents if the claim application of the petitioner is entertained on merits, considering the submission issue.
please. Oblige.
Notice for final disposal.
Yes, please, madam.
Serial number 14, SCA 755023.
And direct service may be permitted, short date can be given.
Sure, direct service permitted. Short.
Oblige, madam.
Whatever. Please, please.
The application for compensate appointment of the petitioner is rejected on the ground that the rule which will apply is 19(2)AB and not 19(3). Lord, I'll tell you lots of some facts. But the father of the petitioner, my lord, he was working with LIC. Lord, in 2019, Lord, he met with a fatal accident. Lord, an application was given for voluntary resignation of service. Lord, that application in the Honorable Court may kindly have a look at page 13.
Yes.
When he was
So prior to accident, he has already
given an application.
Yes.
Now that application specifically recites that on medical count, because I am not been able to, Lord, I'm completely bedridden. I'm not able to even walk. Therefore, I cannot perform my duties. Lord, before that application was accepted, an application was given that please appoint my son in place of mine. Now, Lord, what they say is that as far as application for accepting the VRS is concerned, we will apply 19(2)AB. But nonetheless,
Have
Lord,
you annexed that rule?
yes, as far as
Page
Lord,
number?
Lord, 19(2)B, Lord, I have, because it's a big bunch, therefore I have not
Yes.
annexed. But they have also stated that 19(3) will apply. They have also said that kindly have a look at 19(2)AB. Lord, that your lordship will find at page 15. I'm sorry, Lord, not page 15. Lord, internal page 10 of this rule. Lord, this will apply in case of a general nature where the application is given for VRS. 2A,
Yes.
notwithstanding what is stated in
Just
surplus.
a-
I'm sorry.
It starts with 19. What does it say?
Superannuation and retirement.
Yes.
And then 19(2)AB.
19(2)A,
Yes. Notwithstanding what is stated in subclause 1 and 2 above, an employee may be permitted to retire at any time on completion of the age of 55 years after giving 3 months notice in writing to the appointing authority of his intention to retire. Now, second will be important as far as we are concerned. Notwithstanding the provision of clause A, an employee governed by the LIC pension rules may be permitted to retire at any time after he has completed 21 years of qualifying of service by giving notice of not less than 90 days in writing to the appointing authority. Provided that this option shall not apply to an employee who is on dependent, the rest of the things will not apply.
Not apply.
So they say that we have accepted your superannuation, rather VRS, under this rule. So therefore, we will not be able to.
They have accepted under 2AB.
See, that is what they say. But my lord, the fact that they have stated that we have accepted our application on medical count. Now medical counts, my lord, if the application is accepted, then the rule which is at page 51 will apply. So kindly have a look at page 50 first.
50?
50. Lord, this was given to under ITI. Lord, first column. First column, Lord.
Yes.
Provide full details about law regulation of compassionate appointment in medical retirement.
Only a minute. I couldn't get any page. Acha, 50 of your petition.
Yes, 50 of the petition. Lord. But there are two separate rules as far as
50.
50.
Yes, please read.
Yes. Provide full details about law regulation of compassionate appointment in medical retirement. Appointment on the compassionate ground in the corporation is governed by as per the provisions of LIC of India recruitment rules so and so. Clause 21 of LIC so and so instruction deals with the compassionate appointment. Copy of the rules regarding the compassionate appointment clause 21 of so and so rules is attached. Now, Lord, that the Honorable Court will find at page 51. And Lord, before that, Lord, number 3 also. From which ground the VRS of Mr. So and so is sanctioned? The answer is the VRS of A. Surya was sanctioned on the health grounds. Date of the approval of application is so and so. Now, if the VRS is sanctioned on health ground, then we'll page 51. There shall be a relaxation in upper age limit and educational qualification of near relative in below of an employee who dies while in service as prescribed so and so, where an employee is retired prematurely under regulation 19.3 of staff regulation on health grounds or on being incapacitated for continuous service at least 5 years before the date of superannuation, the compassionate appointment may be made of one of the relative mentioned to below the candidate satisfying all the prescribed.
This is made under which provision? These rules are made under
This
LIC.
This LIC recruitment of class 3 and 4 staff instruction rules 1993.
And
These are, my lord, the main rules.
So,
my lord, therefore, there will be 2 rules.
oh, that is true.
Yes. My lord, these are the rules of LIC.
Which will prevail that.
Oh, they said that we have accepted an application on medical grounds, but Apurva Kapadia.
Apurva Kapadia for the petitioner, he submitted that though the petitioner is eligible for compassionate appointment under rule 90 into bracket 3 of Life Insurance Corporation of India staff, that is
no,
then
this rule of LIC of India
page
recruitment
51,
page
yes.
50. LIC of India recruitment into bracket of class 3 and 4 staff regulations 1993.
Where do I get that?
Below page 50, page 550, below top. Appointment on the compassionate ground in the corporation is governed by
LIC of India into LIC of India recruitment into bracket of class 3 and 4 staff instructions 1993 by wrong application of the rule under Life Insurance Corporation of India into bracket staff from staff rules 1960. The application of the petitioner has been rejected. Considering the submission issue notice that is on page number 50. And quote this is to be taken. Do I get this?
Yes. Can I take direct service?
Direct service.
Publish.
In SCA 7556 of 23 Mr.
Please. It's in a similar matter, notice has been issued to this honorable court where the workman has challenged the inaction of the corporation. Whereas the corporation is challenging the order passed by the labor court. The main issue there was that he was removed under section 56(2)(g) of the BPMC Act. That's whereby he had then opportunity of approaching the higher authority within the act itself. He was not dismissed for under the relevant provision of the act.
Mr. For the petitioner, he submitted that the issue similar issue involving SCA number 2686 of 2020-23 is pending before this court, considering the submission issue notice to be heard along with, not to be listed along with.
Please.
Yeah,
Great.
that's-
Yes, my lord, the London Labour Court has granted lump sum compensation of rupees 50,000, my lord. Though, my lord, there is a finding that the termination was illegal, my lord. 104 is my lord finding.
What were you doing?
My lord,
You
he
were a
was,
daily verger?
yes, my lord, he was appointed as driver. My appointment order is at page 24, my lord.
How much wage you were paid?
My lord, at the relevant point of time, rupees 2,000. I'm sorry, 5,000. My page 24, my lord, this is the appointment order,
Yes,
and that appointment order, clause 14,
yes.
the one condition, and on that grounds, the London Labour Court has come to the conclusion that there was no compliance of that condition, and therefore the termination was illegal. 50,000 is granted. There is a 1 year service, my lord.
Then
Yeah.
there is a
But
question.
my respectful submission is that my one judgment of the Honorable Supreme Court, my lord. In that matter, 1 year service, 25 years was delay in raising the dispute, 1 lakh is granted, my lord. Paragraph 11, my lord, last page.
There can't be comparison with,
Well, this is, may I read my lord, paragraph 11?
yes, please read.
Here also, a case where the respondent claimed to have worked as daily wager hardly for a period of 1 year or so in PWD of the state. Secondly, he had no right to claim regularization. Thirdly, he had no right to continue as daily wager. And lastly, the dispute was raised by the respondent after 25
BSNL
years.
has been referred.
Pardon.
BSNL has been referred.
Yes, my lord. It is after considering the BSNL, my lord. And my lord, after considering the judgments of the Honorable Apex Court, my lord, the court has come to the conclusion that 1 lakh is, my lord, appropriate. Last paragraph, my lord, 15 and 16. So only my request is that some enhancement maybe is required, my lord. In that case, there was a 25 years delay in raising the dispute, and the Honorable Apex Court has granted it.
Honorable Mr.
And this one.
N.D. Sonagra for the petitioner. He submitted that though the petitioner's termination was held to be illegal by Labor Court, Palanpur, only compensation of rupees 50,000 has been awarded. Full stop. He submitted that the compensation is meager and Labor Court ought to have considered higher compensation considering the nature of work
Yes,
he was doing, and he was getting 5,000 rupees
5,000 rupees.
and the minimum wages and the salary or the wage, salary so, and the wage he was getting. In support of his submissions, relied upon decision of Supreme Court in the case of so-and-so versus so-and-so 2019-14 SEC 353. Issue notice only in relation to compensation.
Please.
Amount of compensation.
Please, oblige.
17, SCA 7989 of 23.
I have already shortened the prayer. These are drafted.
Yes.
It is there. Now issue is, I'll place in at 2:30.
The petitioners were the retired employees of Gujarat State Road Transport Corporation. The as per the revised rules of 2009 rules, 6 pay revision of pay rules, which came into force with effect from 1/1/2006, the same provides for granting dearness allowance, recalculated of dearness allowance on the basis of merger of 50% of dearness allowance into basic pay, and the figure would be given nomenclature as dearness pay. On that basis, entire salary and other benefits were ordered to be recalculated. So it's a merger. So basic wages would be increased. Dearness allowance
It's part of
50%.
your salary. That's what
Lordships,
that is.
that is Lord.
Page C, Annexure C, page.
Lordships, there are orders up to Honorable Division Bench, but we have not been granted. We made number of representations. There are 2 orders of the Honorable Coordinate Bench. Consider and decide, consider and decide. But they have not. I'll
Hold on, good Mr. Majmudar for the.
leave to amend prayer clause.
Leave to amend
Lordships.
prayer clause. To be, leave to amend prayer clause to be
Lordships.
carried out, amendment to be carried out in a period of
2 days. Today
from
it is
2 days from today. Learned Mr. N.K. Majmudar for the petitioner, he submitted that despite this, the orders were not in with regard to GLSRTC,
Yes, your Lordship.
despite the orders of this court granting benefit of dearness allowance.
Merger of 50% dearness allowance into dearness pay and recalculated of wages and salary.
Despite order of this court granting benefit of 50% of dearness pay to be merged with basic pay,
Lordships.
the petitioners have been denied the said benefit. Full stop. Even the representation
I will point to
in this regard
Lordships.
dated 6th May 2018 is not responded to. Considering the submission, issue notice.
May I pray for only prayer, notice for final disposal, so that they may come with the preparation if it appeals. Nothing to be opposed, nothing to be argued on my end.
Let them come.
Lordships, direct service, Lordship.
Direct, sir.
Only very innocuous prayer, genuine innocuous. Lordships have said 50% dearness pay merger, dearness allowance, 50% dearness allowance to be merged in basic pay.
50% of dearness allowance to be merged into
Basic pay.
basic pay.
Lordships,
I
that
said
is
merger. Then you correct me. I was understanding correctly that
Lordships. No, my lords were absolutely.
Yes.
I
dearness 50% of dearness
allowance
to be merged into basic pay.
and then only academic. Then that figure would be called dearness pay. So all benefits, salary.
Academics you learn makes me learn.
Lordships, I am grateful. I am sorry. Oblige your Lordship. तो आमा amendment में prayers to एकदम split and short.
Draft amendment
We are
allowed to be
Lordships.
carried out within a period of 2 days from today.
The issue is petitioners are laboratory technicians of government authorities. We were appointed as per regular recruitment rules in COVID-19. Even as per Gujarat Civil Services.
Yes, separate. Yes, who appears for the state notice? Because see, then it was they worked for the whole period.
And even Sunday also. So only we are seeking salary or Lordship.
Notice, yes.
Here I may pray notice or final disposal. Where genuinely short issue.
Some date will be given.
Lordships. Direct service. Oblige your Lordship.
Can't I see first my prayer?
Why you want to be at par with
Even my lord, the award confirmed by the division bench of this honorable court. And the contempt petition was filed in contempt petition, my lord.
you are
is
treated as a permanent?
Yes, my lord, award is of 98
That was not implemented, and then I filed the petition. Petition not allowed.
So that is the reason you want to treat yourself to be at par with the regular employees.
Yes.
That award.
Award is my lord page 26/M.
Mr. VP Mishra for the petitioner. Issue notice.
Number 20, SC 8733, Mr.
Please, Your Lordship. Lordship, on the earlier occasion, a draft amendment was required to be carried out.
What is the case?
Lordship, the petitioner was working with the bank. And after the merging of the bank, some of the employees were relieved, and in which one of the name was of petitioner.
Sorry, once again.
A petitioner was working with the respondent bank, Canara Bank. After the merging with the syndicate bank, in the merger, after the merger has been taken place, some of the employees were relieved, and some of the lower post employees were relieved, and in which one of the name was of the petitioner.
So you have been relieved.
We were being relieved.
Then
was the petitioner was working with the Canara Bank as a housekeeper.
What was your appointment, please? What happened? Any other petition, those who have been relieved, because along with you, large number of employees were.
As per my instructions, no other petitions. I'm not having. After the merger, before merger, he was working as the housekeeper in the Canara Bank. After the merger, no housekeeper was appointed, and the.
Is there any sanction post? How can you seek appointment? You need to come out specifically. That's what I asked you on the last occasion. Then how can you my.
Then may I request for a passover, Your Lordship? Mr. Satta would be the best person to assist.
So you said that you regularize me, but when you are not in service, where is the question of regularization?
Yes, Your Lordship.
Bill number 21, SC 8737 of 23, last word.
And on last occasion, my lord said directed the petitioner to place a draft amendment.
Yes.
It was filed in the registry.
Yes,
Here I
yes.
have specifically contended that petitioners are absolute identical petitioners to who had filed special civil application number 6111 of 2014, and hence accordingly I have modified a prayer that the petitioner may also be granted the very said benefits which were granted to those petitioners.
What were the benefits you are?
Yes, my lordship. That I am at present the petitioner was appointed on fixed pay basis. He was granted a salary of rupees 20,000 per month. Now, if my lords can peruse page number 40. This is the relevant
Yes.
part of that judgment.
Earlier
SC,
order
lordship.
of this court, yes.
Yes. Page number 40 addresses the facts. Para number 2, that is the petitioners were appointed in the post of lecturers in Government Polytechnic Valsad as class 2 employees on contract basis for a period of 11 months or till the regular candidates made available for GPSC.
So others were granted higher pay 30,000 and therefore you are seeking
Lordships, same exact same reliefs.
Notice.
The draft amendment had to be
Draft
allowed.
amendment
Okay.
allowed to be carried out within a period of 1 week from today.
Lordships. I'm grateful, my lords.
Number 22, SCA 9093 of 23, Mr. Carpenter.
You carried out within a period of 2 days, otherwise notice will not go. Baby discussion. Yes.
Requesting for a password, madam.
Number 23, SCA 9203 of 23, Mr. Suresh Patel. Please.
Hello, seeking benefit of leave encashment. Only leave encashment.
Yes, who appears?
The two is it is a.
Panchayat.
No, it is a public service entity. So.
Notice.
We have adapted the not.
Notice.
Please, Your Lordship.
Issue pertains to grant of 300 days leave encashment. Issue notice.
Deeply open.
Bill number 24. SCA 9896 of 23, Mr. Vishwesh Gujarath.
Please, we should continue to leave in question.
Same issue. It is a PS. So
PSU,
it is the so only notice will be issued to.
but would petition would lie?
Yes, ma'am.
It's a government, government state. It's a government and PSU. Public sector. Chara, will you apo to? Yes, notice.
Bill number 25, SCA 9910 of 23, Mr. Vaibhav Vyas.
Please. Not the request of the petitioner for granting him the benefit of deemed date of promotion came to be rejected by the respondent authority. But the impugned order is on page 14.
Yes, please. Read that.
Please notes. Now, it is the case of the respondent authority that not the petitioner was entitled for the grant of that benefit. However, now since the employee who has been promoted prior in point of time has already retired from service, and therefore he cannot be reverted from service. Therefore, you cannot be granted the deemed date of promotion. That is what please notes.
You are seeking your claim with parity with whom?
S.B. Patel,
Yes,
note page
please.
13.
Please. ઉપરોક્ત વિષય
Please notes. May I read the order? ઉપરોક્ત વિષય અન્વયે જણાવવાનું કે તેઓની વર્તુળ કચેરીમાં ફરજ બજાવતા H.G. હડિયા તત્કાલીન કારકુન હાલ હિસાબનીશ એ તારીખ 28/12/2021 ની અરજીથી તેઓના જુનિયર શ્રી S.B. પટેલ સામે હિસાબની સંવર્ગમાં ડીમ ડેટ મંજૂર કરવા રજૂઆત કરેલ છે. તેઓ બંને કર્મચારીઓની વિગત સેવા પોથી આધારે તૈયાર કરી તુલનાત્મક પત્રક નીચે મુજબ રજૂ કરેલ છે.
Please comparison show
Please notes.
that બંનેની તારીખ
Lord senior Lord item number 2 કારકુન તરીકે
હા પહેલા તો you have જોડાયા તારીખ
95 and he joined in 75.
75.
Lord કારકુન તરીકે seniority ક્રમાંક
Yes.
1/4/2015 ની યાદી મુજબ Lord he seniority is at 902 and my seniority is at 864.
Why it is so?
Lord initially what they did, Lord, was that Lord the seniority was counted on the basis of Lord continuous officiation. Lord subsequently Lord the rules provided that the seniority is to be counted from the date of passing of the examination and the merit rank which is obtained in the examination.
So because of he was having a lesser merit.
Please, my lord. I was Lord undisputedly, my lord, I was senior to him, Lord. But because of Lord the earlier seniority list, my lord, he came to be promoted first in point of time. Lord, item number 6.
પૂર્વ સેવા પરીક્ષા પાસ કર્યાનો માસ તથા વર્ષ
નોંધ નથી.
એની પાસે નથી, તમારી પાસે 97.
જી. કારકુન તરીકેની ખાતાકીય પરીક્ષા પાસ કર્યાનો માસ વર્ષ મેરિટ ક્રમ તથા કેટલા પ્રયત્ન પાસ કરેલ છે. બીજી May 1999 merit 10. But I cleared in the first chance, he cleared in the second chance. Not I cleared in May 1998, that is prior to him, and my merit rank was serial number 1. Then Lord, the accountant's examination, Lords, which is also required to be cleared. They are both of them cleared in the first round, first attempt, but he cleared in October 1999. I cleared in November 1998 at merit rank number 1. He was at merit rank number 10. But considering this, Lord, the seniority positions were changed in the year 2015, wherein Lord, he was shown as junior to me, so far as clerk's cadre is concerned. But thereafter, Lord, the date of promotion is stated. Item number 6 would be relevant, Lords. But he got promotion on 25/7/2002, but the petitioner got.
Straight we go to page 14, last paragraph.
Please, Lords.
તે મુજબ સને
તે મુજબ સને 2011 માં તેનો અમલ કરવામાં આવેલો હતો. સરકારશ્રીના વન અને પર્યાવરણ વિભાગના તારીખ 22/9/2010 ની સૂચના મુજબ શ્રી પટેલને સને 2011 અગાઉની પ્રવર્તા યાદીથી મેળવેલ બઢતીમાં તેઓને રિવર્ટ કરવાના થતા હતા, પરંતુ તેઓ આ સૂચના મળ્યા અગાઉ.
He was not in service. How when is the question of reversal? Because he might have retired.
He has retired from
You also retired?
No, I am in service,
You
Lord.
are in service.
I am in service. Therefore, my lord, they say that since he has attained the age of superannuation, now he cannot be reverted, and therefore you
Reverse of-
cannot be granted the benefit.
Page 11.
They both are in the same cadre.
Lordships, the deemed date of promotion, which the petitioner is asking, the cause of action has arisen in 2002.
Four.
2002. If a lordships may kindly have the prayer on page 11.
Yes.
8A. Caution set aside the impure order dated so and so, which is just read by my learned friend. And further be pleased to direct the respondent authorities to grant the benefit of deemed rate of promotion to the petitioner in the cadre of accountant with effect from 25/7/2002. That is the date on which the junior to the petitioner was granted promotion. 2002 is when your right is accrued. The very first application comes when your lordships on page 13, 1-3, the impure order.
22.
2021.
21.
So since 2002 to 2011, you first time you come before the authority and say that this is my grievance. Now since 2002 to 2011, 2021, much water has flown. The person has already retired in 2007, with whom the parity is being claimed. If at the correct point of time, in the year 2002, if the grievance would have been raised, some actions could have been taken, your lordship. The person has retired in 2007. The right is accruing in 2002. 2021 is the first application you are making.
Yes. But why you have answered this wise? You could have said your application is required.
But in fact, Lord, earlier when the application was moved, page 18 may kindly be seen, Lords. But at that point of time, Lord, the seniority list was not finalized. It appears, Lords. But therefore, the petitioner was informed that on the basis of a provisional seniority list, you cannot be granted the benefit of deemed date of promotion. Therefore, you make an application after the seniority list is finalized.
But
Not
that
page,
is in the year 2020.
please note, page 18.
So, lordship, since 2002, if the right is accrued. Now, to turn the wheels back to a person who has already retired in 2007, your lordship, we have said categorically on page 14, we say that yes, this is required to be done, but the person is retired in 2007. It's been 21 years now since your right has accrued.
How would you justify delay?
It appears that the seniority list was not finalized not by the authorities themselves. But page 18 may kindly be seen for a moment,
But
Lord.
for that, there must be provisional seniority list.
Yes, and the, yes, therefore, Lord, Lord, may
Now,
kindly
in that context,
page-
turn to page 13.
page 18 may kindly be seen for a moment, Lord.
Please turn to page 13.
Page 13. Please note. May I read the second paragraph, Lord? After the Lord column. વન ખાતામાં હિસાબ નિશોની બઢતીની જગ્યાઓ કારકુન કમ ટાઈપિસ્ટની પ્રવર્તા યાદી મુજબ બઢતીથી ભરવામાં આવે છે. વન ખાતાના કારકુન કમ ટાઈપિસ્ટની પ્રવર્તા યાદી સરકારશ્રીના તત્કાલીન ખેતી અને સહકાર વિભાગના ઠરાવ ક્રમાંક 100 ની જોગવાઈ મુજબ ખેતી વન અને સહકાર વિભાગના જાહેરનામા ક્રમાંક 100 21/7/1971 થી નિયત કરવામાં આવેલ ખાતાકીય પરીક્ષા પાસ કર્યા તારીખથી તથા પરીક્ષામાં મેળવેલ ગુણ ક્રમાંક મુજબ નક્કી કરવામાં આવે છે. બાદમાં આ ઠરાવો પરિપત્રોના અર્થઘટનમાં વિસંગતતાના કારણે સને 2000 તથા ત્યારબાદ કારકુન ટાઈપિસ્ટની અગાઉની પ્રવર્તા યાદી રદ કરી ખાતામાં દાખલ તારીખ મુજબ પ્રવર્તા ગોઠવીને બઢતીની કાર્યવાહી કરવામાં આવેલ હતી. તે મુજબ શ્રી પટેલને ખાતામાં દાખલ તારીખ 16/12/1975 મુજબ શ્રી હડિયા કરતા વહેલી બઢતી મળી. ત્યારબાદ વિવિધ કર્મચારીઓ દ્વારા લિટિગેશન કોર્ટ કેસો કરવાથી તેનું ભારણ વધતા સરકારશ્રીના વન અને પર્યાવરણ વિભાગના તારીખ 22/9/2010 થી કારકુન કમ ટાઈપિસ્ટની પ્રવર્તા યાદી બાબતે ખેતી અને સહકાર વિભાગના તારીખ 22/12/1970 ઠરાવની જોગવાઈ મુજબ ખેતી વન અને સહકાર વિભાગના 21/7/1971 જાહેરનામાથી નિયત કરવામાં આવેલ ખાતાકીય પરીક્ષા પાસ કર્યા તારીખથી તથા પરીક્ષામાં મેળવેલ ગુણવત્તા ક્રમાંક મુજબ સિનિયોરિટી મુજબ પ્રવર્તા યાદી નક્કી કરી તેનો અમલ કરવા અને હિસાબની સંવર્ગમાં પ્રવર્તા યાદીમાં પણ તે મુજબ જરૂરી ફેરફાર કરવા જણાવેલ. તે મુજબ સને 2011ની સાલમાં તેનો અમલ કરવામાં આવેલો હતો. સરકારશ્રીના વન અને પર્યાવરણ વિભાગના તારીખ 22/9/2010ની સૂચના મુજબ શ્રી પટેલે સને 2011 અગાઉ પ્રવર્તા યાદી ती મેળવેલ બઢતીમાં તેઓને રિવર્ટ કરવાના થતા હતા, પરંતુ તેઓ આ સૂચના મળ્યા અગાઉ તારીખ 16/16 ના રોજ વય નિવૃત્ત થયેલ છે, જેથી વ્યવહારુ રીતે સરકારશ્રીની 22/9/2010 ની સૂચનાઓ અમલ શક્ય ન હતો.
11 એમને તમારે
મિલોડ only a minute, મિલોડ only a minute, મિલોડ મિલોડ may kindly have a look at 22/9/2010 મિલોડ, that is on page 71. May I read note this?
Yes, 2010.
2010 હિસાબની સંવર્ગમાંથી મુખ્ય કારકુન સંવર્ગમાં બઢતી આપવા બાબત ઉપરયુક્ત વિષયના અનુસંધાનમાં જણાવવાનું કે આ વિભાગના તારીખ 25/2/1997 ના સરકાર ક્રમાંકના પત્ર અનુસંધાને જણાવવાનું કે સદરુ પત્રથી કેટલીક પ્રસ્તાવ માંગ
By whom to whom?
not this is by Forest and Environment Department.
But then why you haven't acted upon?
Sorry.
This was, I think, he himself is stated, okay, it is not in,
Thereafter, Lord, the seniority list of the cadre of clerk came to be published, Lord.
no, but then that
Lord,
this
page-
is, I think this document is absolutely in your favor.
Yes, that is in my favor.
22nd of September
Please, Lord.
2010, but then why you haven't acted upon it?
Sorry, Lord.
Then why you haven't acted upon it?
Yes, Lord, thereafter, page 29 may kindly be seen, Lord. Lord, this is letter dated 22nd September 2010. Lord, on the basis of this, in 2016, my Lord, the seniority list, the revised seniority list came to be published of the
First
cadre of,
one to 7, page 71?
please, Lord. Page 29 may kindly be seen, Lord.
Yes.
Lord, reference item number 2, 22/9/2010 નો સરકારશ્રીનો વન અને પર્યાવરણ વિભાગનો પત્ર.
Yes, yes.
On the basis of this, seniority list of the cadre of clerks came to be prepared, my Lord. There, my Lord, the petitioner was shown at serial number 864.
Yes.
And, my Lord, the person against whom the petitioner was claiming his seniority is shown as serial number 902.
So he was, you were shown senior.
I was shown senior.
Yes.
Lord, now, my Lord, my right of seeking, my Lord, deemed date is in the cadre of, my Lord, accountant. Lord, for the post of accountant, my Lord, initially the seniority list came to be published, provisional seniority list came to be published. Lord, immediately after the provisional seniority list was published, the petitioner made a representation to the authority saying that I may be granted deemed date of promotion since S.B. Patel is shown is junior to me and he has been granted promotion. Lord, on the basis of that representation, the petitioner was informed that you cannot be granted seniority on the basis of provisional seniority list. Therefore, after the seniority list is finalized, you may make an application. But that letter may kindly be seen on page 18.
That you read. 2021.
2021. Because this was the first time, my Lord, when the provisional seniority list.
Hold on, Mr. Vaibhav, as for the petitioner, he submitted that despite petitioner was eligible for promotion, at
Deemed
par
it.
with his junior, he was not granted the same on account of final seniority list being not prepared. Considering the submission issue rule
But now the final seniority list is also prepared.
at the relevant time. Acha. He submitted that now the final seniority list is prepared. Despite that, he has not been granted the
Deemed
deemed
date
date of promotion.
Please, Lord.
Full stop. Miss London AGP Miss Thariti Pancholi on advance copy, appeared on advance copy and submitted that for the deemed date of promotion with effect from 2012. The petitioner is 2002. The petitioner has preferred this petition in the year 2023, which suffers from delay and latches. Considering the submission issue rule.
Please, Lord, I'm obliged.
Number 26, SCA 10405 of 23, Mr. Vaibhav, please.
Please, Lord. Or the punishment of dismissal from service, my Lord. But initially, Lord, the petitioner was issued punishment of stoppage of one increment for 2 years, my Lord. But that punishment order is on page 70.
What are the charges?
Yes. But the charges are on page 21.
Yes,
But one is of remaining unauthorizedly absent
yes.
on 1 day. And Lord, the second is Lord, the involvement of the petitioner in prohibition activity. But before the inquiry officer, so far as second charge is concerned, Lord, the inquiry officer has also not considered it as proved, Lord. So far as absence of from duty for 1 day is concerned, Lord, the inquiry officer
So
said.
you are only on the quantum of punishment.
No, yes, ultimately before that, Lord, therefore, before that, Lord, earlier the punishment order was already issued by the authorities. But that punishment was of stoppage of 1 increment for a period of 2 years without any future effect. However, my Lord, this was taken in suo motu review by the higher authority. And my Lord, while taking it in review, my Lord, punishment of dismissal came to
What
be.
is the scope of this court in so far as punishment is concerned?
Please, Lord, Lord, if
Have they followed the procedure?
procedure is followed, but so far as the procedure,
Any malafide you have alleged?
no,
Then tell
no.
me it's a
Therefore, my Lord,
criminal.
Lord, while reviewing and while imposing punishment of dismissal from service, Lord, the reviewing authority has not recorded any disagreement so far as second charge is concerned, Lord. Lord, to that extent, Lord, there is a procedural lapse which I am trying to
So
explain.
the disciplinary authority has.
Has taken into
disagreed
consideration.
with the-
No, there is no disagreement. But your lordship may kindly appreciate. But the inquiry officer says that charge number 1 is proved, charge number 2 is not proved. But my immediate disciplinary authority says that yes, on the basis of this charge, I am imposing punishment of stoppage of increment. But this is taken into review after a period of more than 2 years. Not while taking it in review, but I am not given any notice to the effect that though the inquiry officer has stated that second charge is not proved, I am of the opinion that second charge is also required to be proved. Therefore, there is no notice.
So you were not put to show cause?
Show cause notice was issued as to why the punishment of stoppage of increment be not converted to dismissal from service.
Then where is the?
But
question?
Lord, while imposing final punishment order, the authority takes into consideration both the charges, Lord. Therefore, I am on the point that, Lord, so far as second charge is concerned, Lord, there has to be a specific disagreement. But if the inquiry officer is saying,
So from not proved to he turned to proved.
please, Lord,
Therefore,
yes.
notice
Therefore,
is
there
required.
to that extent, Lord, there is a procedural lapse. Coupled with the fact, Lord, that Lord, coupled with the fact that in any case, Lord, my disciplinary authority was my immediate superior authority. Lord, had taken into consideration the charge which was leveled against me as proved, and on the basis thereof, punishment of withholding of increment came to be issued. Lord, it is a matter of record, Lord, that Lord, so far as the charge of unauthorized absence of 1 day is concerned, Lord, the petitioner was on duty for continuous 51 hours, Lord. Lord, he had taken leave of Lord the immediate Lord the commander, Lord, and had gone on leave on the next day.
What were you doing?
The petitioner was working as an armed police constable.
For EVM machines.
Yes.
The gravity of the whole situation and such order comes because he was guarding EVM machines, my lords. Imagine the repercussions which could have come in if there had been something. My lords, I will take my lords so because this is a matter where I believe my lords does not even deserve a notice. My lords may have.
Now let him complete loud. Gather the facts, please. Mr. Vyas,
Please, Lord.
only page number you just show me.
Page number 70.
Page 17 is
7070, Lords. The punishment order dated 17/11/2021. Before that, I'm not show cause notice and not the report of the inquiry officer.
just a minute. Page 70 is the
Punishment order.
penalty order. Dated
17/11/2021.
prior to that, you were given
Show cause notice along with the report of the inquiry officer.
show cause, page number,
41.
page 41,
Please note.
along with
Report of the inquiry officer.
your report. Yes. So principles of natural justice are complied with. You were
Please
put to notice. Yes. Then what happened?
Now the petitioner replied to it. And thereafter punishment order on page 70.
Your reply? His reply?
My reply is on page 66, Lord.
66 and punishment order page 70. Yes. What are your grounds?
Punishment
First-
order may kindly be looked at, Lords, page 70.
Yes.
Page 71 may I read, notes? વધારાની સમીક્ષા અને આખરી હુકમ કસૂરદારને અમુક 13/5/2021 ફરમાવેલ આરોપનામાની તારીખ 16 રોજ બજાવણી થયેલ છે. બચાવ રજૂ કરેલ.
I've seen. Now, but let's go to now. What are the submissions? It's disproportionate first.
This is not the stoppage of one increment for 2 years.
Page 70 is the first.
First punishment order. This is the first punishment order. Notes. I am not challenging this punishment order. Notes.
Yes. Then suo motu revision.
Yes, Lord.
Suo motu revision.
Lord, notice
Page
was
number?
issued on 14/12/2022.
Page number
73.
73. You replied?
Yes.
Yes, you replied to that?
Yes, I replied to that, Lord.
Page number
76.
76.
then final order.
Then final order.
Page 16.
Page number
60. 16.
Lord, may kindly have a look at page 74 for a moment, Lords. The
No,
show cause
wait.
notice.
that order. Acha, page 70.
Page 76, Lord.
76.
73 is the show cause notice. Lord, I want to point out from page
Yes.
73.
So show cause.
Show cause notice.
Yes. I thought you want to refer to earlier order.
No, no.
Yes. Yes.
Page 74, Lords. May I read? Second last paragraph.
Yes.
74.
Yes.
આમ
please.
પોલીસ કોન્સ્ટેબલ સો એન્ડ સો વિરુદ્ધના ખાતાકીય તપાસના કાગળો અવલોકનને લઈ આ પ્રકરણનો કાળજીપૂર્વક અને તુલનાત્મક અભ્યાસ કરતા મજકૂર આર્મ્ડ પોલીસ કોન્સ્ટેબલ ઈવીએમ મશીનનો ગાર્ડ જેવી અગત્યની ફરજ ઉપરથી ગેરહાજર રહેલ અને પ્રોહિબિશન જેવી ગેરકાયદેસર પ્રવૃત્તિમાં સંડોવાયેલ છે. Not this charge was held to be not proved by the inquiry officer. Prohibition જેવી ગેરકાયદેસરની પ્રવૃત્તિમાં સંડોવાયેલ છે. તેઓની ખૂબ જ અગત્યની ફરજોનો ત્યાગ કરી કોઈ પણ પ્રકારની મંજૂરી લીધા સિવાય ફરજ ઉપરથી અનધિકૃત રીતે ગેરહાજર રહેલ છે, જે ધ્યાને લેતા પોલીસ અધિક્ષક શ્રી નવસારીના
Yes.
તારીખ 16
Yes, understood. Then what happened?
ખૂબ જ હળવી જણાય છે. Then, Lord, I replied to this. Lord, I pointed out to the authorities, Lord, that, Lord, I was on duty continuously from 3rd April 2021 to
Yes.
5/4/2021. Lord, in the reply, Lord, even this was considered by the
Then-
earlier
then
authority.
You need to take a sanction leave.
Lord, I had informed,
If you
Lord, the,
feel that you have worked continuously.
yes,
then you
51 hours, Lord,
Then that, understood. But then you need to.
Lord,
give an
it was my case
application.
that, Lord, I had obtained leave of the commander. Lord, the commander also says, Lord, in his deposition that he was on duty. Lord, the person who was to relieve me was not, did not report for duty. But
Yes.
therefore, my Lord, I had to do double duty.
Yes.
But after, my Lord, the person reported, my Lord, I was given a leave. My Lord, I was, I had informed and I gone. My Lord, it is not the case that without
Yes.
informing, my Lord, I
Then
had left the,
yes, what are your submissions? That first is
first is, yes, so far as prohibition case is concerned, Lord, at the time when the second notice came to be issued,
prohibition not proved.
yes, the judgment and order of acquittal was also annexed along with this.
By IO, it was not proved.
It was by IO, it was not proved. Even, my Lord, when the second show cause notice came to be issued for dismissal from service, at that point of time, Lord, I was acquitted from, Lord, the prohibition case. But the judgment and order of acquittal was also annexed with my reply to the authorities.
Yes. Order of acquittal. Yes. Then,
Page 79, Lord, is, Lord, there is a mention of, Lord,
yes.
annex.
Yes,
It is not the case
understood.
that this was not given. But now the punishment order on page 16.
Yes.
The paragraph on page 18, may I read, Lords? Sahid Kramang so and so. First line from the top, my Lord.
Uh-huh.
No, deposition of the witnesses are quoted, my Lords. Sahit Ramank, Head Constable, Raman Bhai, Jaising Bhai.
That this court will not go into that.
Your Lordship, my lord, so far as appreciation of evidence is concerned, your Lordships will have to.
It is to be, you say that certain evidence which is required to be considered is not considered, or it is perverse to the.
Please, Lord, please, Lord. That, for that purpose, my lord.
Yes.
No, I will not read the entire paragraph. Only one paragraph, my lord,
Yes.
on the top, my lords. Armed hand.
બીજા માણસોને નતા ફાળવ્યા એટલા માટે I couldn't, I went.
Ji.
That sort of basis. And that defense has not been considered by awarding the final penalty.
And my lord, the prohibition offense is also taken into consideration.
Will continue to.
Please, lord.
I will take instructions on this matter. I'm withdrawing. The mere request is that the lordship could just incorporate that upon instructions.
What's the good name, please?
Vanilla.
Please provide a
Yeah,
cheat.
I'll provide it.
You are for the petitioner.
Yes, for the.
My lords, I am on behalf of respondents, on behalf of Ms. Aishwarya Gupta.
Please provide a cheat of your appearance.
Yes, Your Lordship.
Okay.
What do we know? Statement. I'll explain. Barcode board, PC board, the code. Mr. Vanilla planning for petition upon instruction of his client. 6, permission to withdraw. Permission to wait for this. This post office withdrawn this.
Yeah, serial number 117. By
Yeah.
consent, I request for 3 weeks time.
The matter which are at a later stage won't be taken up, so appropriate date will be given. Please don't mention. Yes, please. Say yes.
I'm requesting for dispensation of salary receipts which are placed on record. They are legible. I just wanted to
Dispense.
please.
Yes,
Ship
please.
serial number,
The
What?
document is legible with the
It is legible.
undertaking. Yes, please.
Yes.
serial number 104, Lordships. In this matter, I am appearing with senior advocate Mr. Mehta. Here, Lordships, last time also Mr. Munsa, this is a covered matter of stigmatic termination. Last time also Mr. Munsa said he will file reply. Today also same, I am unable to take priority. Some shorter date may be granted. Grateful, Lordship.
May I have the liberty to mention, Lord, serial number 71, Lord. Lord, here there is some urgency, Lord. There is no reply from the state or
Yes,
Lord, from the
state.
district development officer.
71.
Lord, therefore, the request would be that
Shorter date. Yes.
because Lord, otherwise it would become infructuous.
Shorter
Please, Lord,
date.
I am obliged.
That's trying to list the matter for the purpose of withdrawing only.
Right. Yes.
Thank you.
Yes, please provide. Yes.
Requesting for circulation of one civil application, wherein the respondents authorities are granting the promotion to the seniors to the present petitioner. On apprehension, we have prepared a petition, but at that point of time, no circular was passed with respect to the same. Now they have issued and call for the rematch color. Immediately, they will grant the promotion. Therefore, if it can be granted on
When the main matter is coming,
on 30th of this month.
then what is the urgency?
So therefore, that civil application. may
Civil
come on
application is allowed.
30th.
Yes, chalo. Please, yes, please.
Serial number.
And one another request for one special civil application wherein all the documents are legible, that type copy may be digital. Please.
It will come in due course. Yes.
Please. No.
Yes, please.
4344. The cognate appeal that other employees notice has been issued. So I'm providing that cheat.
33,
43 and 44.
43 and 44. Yes.
Yes, to be heard with I
Serial
am.
number and petition number.
Yes,
Otherwise
I have-
it will not, no orders.
I have provided the matter number and
Yes.
next date.
33 and
43 and 44
43, 44
to be heard with, and
to be heard with. Happy the orders.
for respondent number 3 I will take direct service because
One who
Yes.
could waive.
3 is a Nagar Palika is contesting party and Mr. Makad. So I will serve.
So direct service to all the respondents.
Please, Lord.
Direct service. Yes, please.
Serial number 114, which I have mentioned in the. Called out because 1992 order is the challenge.
43.
Mine is 43, 44.
Yes, serial number 114, but my lords have asked me to call the other side in case if the other side is there, the matter may be taken. The
What
matter
is-
is pertaining to execution of recovery certificate. Lordship notice has been mentioned if my lords may take.
Yes, please, we'll take.
It can be
after-
disposed of
Yes,
by giving
yes,
direction.
Serial number 3 in the regular form. That civil application, I am not pressing also.
Civil application is. From Mr. Gaurav Sudasma for the applicant upon instruction of his client states that he does not press. He's not pressing the application, it's his case. Civil
Please.
application is disposed of as not pressed. Yes.
So far as serial number 1 in Barcode board. Wherein also, as per the Malas.
Same.
Yes, no, same, but Malas here the participation. He is ready and willing to.
But then we,
Malas, in the morning. Your lordship has said that if he is ready and willing to withdraw the whole petition,
He
then,
may be permitted to
yes, yes.
fill application
so
number
far as-
1 of 2023, heard Learned Mr. Gaurav Churasna for the applicant. He submitted that pursuant to the policy dated
2/6.
2/6/2022, 2/6/2023, into bracket new policy. The applicant is eligible to participate in a transfer camp. He submitted that if his application to participate in the new camp, if any application is filed by him and if the same is considered by the respondent, he would withdraw. Read petition, special civil,
Petition number 1.
special civil application for respondent for petition number 1.
And so for the rest of applicants, I am not pressing these.
Considering the submission, the petition is withdrawn, response number 1. Consequently, the civil application is disposed of or not pressed.
Not pressed.
Not pressed for all the applicants.
Please.
My lord, here, which my lord have withdraw petition for number 1, but she has not filed any application also.
And I
If
said-
filed, because if filed.
Lakshman and Mr. Then I said, if filed.
Yes, lordship.
Mr.
She has not
Mr.
filed.
Patel on advance copy, Mr. Patel on advance copy stated that no application is,
No, my lord, that is.
no application to participate in the transfer camp is filed.
Number 1 છે.
Therefore,
Yes,
if
she has not
any
filed.
file, મને બતાવી દેજો order, please. If any file, yes, please check.
Matter number 3.
Please.
I'll before signing, I'll look,
Lordship.
I'll check.
Please.
Yes, please.
Because my learned friend
Yes.
is saying with respect to serial number 3, I am,
No issues, I'll
please.
check. once.
Lordship.
Application, if any file.
If any,
Please,
certainly,
please.
then we have to.
Yes,
consider.
Yes,
Lordship.
yes, yes,
Serial number
sir.
96.
Yes, please,
Lord, serial number 96, my lord.
yes.
There, the identical order is required to be passed. He has to place the notification on record. Covered matter.
Only thing, central government notification is there, issuing that.
Anything to be added, then I'll not.
No, kindly.
No, no, no.
Tomorrow.
5 other matter, identical matters are already disposed of. Only one, this one was left out, my lord.
On the contrary, I am placing it on record,
Yes.
certain order.
Please, please,
Oblige.
tomorrow. Sorry.
Lordship, oblige.
Five minutes to please wait, Mr. Yes, please. No, no mentioning over, so yes. Number 98. Yes.
Well, my lord had asked me to take instructions regarding 17B.
Yes, he has filed.
Yes, yes, right. I've talked to the clients. So they have multi-layered management, therefore, final instructions are not been able to get. I don't know whether the matter could be kept next week or Monday. Then I will be able to take
It
instructions.
is better that you seek instructions, and if the management is agreeable, then it would be easy for him
Please, sir.
to get ek week રાહ જોવાશે, so it is better for you. બરાબર? By
And my request also would be, it might be sat down for immediate final hearing also. Because the issues involved are same which I am going to argue for in support of my contention for states. Issues are same. But no, that can be examined, my
Yes.
request can be
but
examined on that
timing,
day.
I'm putting it on 3rd of July,
Please, sir.
Monday,
Please.
so that at least on
By that
17th.
time, I will get final.
At least his grievance will be fourth. So his grievance will be substantially redressed if he gets some money by way of 17.
And the
days.
matter could be disposed of.
Yes, so that is
Please, sir. Please.
fourth.
Because the issues are the same.
Yes, but by that time, please get the instructions.
I will get the instructions.
So now it is,
I will talk to the people, madam.
yes,
We are getting the instructions
yes.
finally.
Because now it's mandatory. Only thing it is to be
I
paid
know.
as per the,
Number of judgments are there, but
Please.
I want not to trouble your.
No, no, it's okay.
Right.
So that I took it at 2:30 since you were waiting.
Obliged, Your Worship.
Thank you.
One question, that same case is available in same court.
Sorry,
This case is available in.
So what my learner, what?
main matter also?
No, main
No.
matter, I'm just talking about.
The matter will remain before this court. That is,
That I can't. say.
that is what he wants to do.
That- Let's see that at the
I
moment.
have
I'm
also
short.
not heard of any change in this.
That's right.
I am not. Please.
Please, Your Worship.
Continue.
So continues. Figure number 26. Mr. Vaibhav, yes.
Yes, you were referring to?
Please note, I was referring to the punishment order.
Yes. Page.
Page 18.
Yes, you were referring to page 16 and page 18.
Yes, ma'am.
Yes, please continue.
Page 18 top, side क्रमांक 1. Armed head
Ha,
constable.
let that you showed કે કોઈ હતું નહીં એટલે he continued for a.
No, he continued for
55
3 days, my lord, continuously. And my lord, after my lord, he was to remain on duty up to 5/4/2021 up to 8 hours. But in spite of that, my lord, he had remained on.
So this aspect has not been considered. That's what your submission is.
No, my lord, the disciplinary authority had considered all the aspects. No, this was the only charge which was held to be proved against me by the disciplinary by the inquiry officer.
But he has not passed a reason order. While differing with the findings of the
No,
inquiry
not
officer.
the disciplinary authority did not differ with the findings of the inquiry officer. The disciplinary authority, relying upon the inquiry report and considering my representation, was of the view that punishment of stoppage of 1 increment for 2 years without
Then
future effect.
subsequently suo moto revision.
Suo moto
It
revision.
changed.
Lord, while taking it in suo moto revision, Lord, the authority take into consideration both the charges. But
And-
my respectful submission to the honorable court is to the effect that, Lord, so far as second charge is concerned, Lord, not the inquiry officer.
Which charge? Prohibition.
Prohibition charge.
Yes.
But the inquiry officer has specifically recorded that that charge is not proved against not the petitioner. Therefore, my lord, while taking into not when the inquiry officer has recorded a finding in favor of not the employee, delinquent employee, not without recording any disagreement to that finding, not that observation or that charge could not have been taken into consideration for the purpose of passing of the.
In that is,
And Lord,
you
lastly,
understand, see, when you are deviating from the findings of,
I will make good.
see, so far as, let's go stage wise, I think IO's report is there, IO said these charges are not proved. Thereafter, disciplinary authority says that is the only stoppage of 2 increments in the first house. Then there is a suo moto revision, which he has a power. So no one
What
is,
is that suo moto revision? Wow, what extent it will go? My lord may refer. My lord may just give me a few.
yes, but what about the quantum or the disproportionate penalty? See, I understand that he was holding a very responsible, but a person having worked for 51 hours a day, 51 hours day and night, you have not disputed.
I pose a question.
So you have you disputed that fact?
But I pose a question to myself today, that when such a thing is to happen, would that give them the right to go on a leave for any appropriate stage?
That is true.
Now, this is the same time when my lord allegations.
Therefore, the question of proportionality. See, it is to be balanced. He has not taken leave. You have asked, compel him to work beyond the capacity. So therefore, the disproportionality. Where is the question of proportionality come?
But my lord, may again, what was the responsibility affiliated upon him? My lords, here is an officer who was given the responsibility of an EVM machine. My lords are aware that in a democratic functioning of the society, the elected governments are formed through the EVM machine, my lords. And if any mishap was to happen, it would have created a chaos. Are aware how things can go haywire.
That you are absolutely right. But then you can't for that reason permit him to ask, continue for 51 hours.
But he could have had a presentation. And then that, see, I'm not getting, I'm treated inhumanly, I've been working of such long hours. When he has not challenged his responsibilities and his duties, here is a person who is.
Therefore, disproportionality. Therefore, this.
Then, my lord, just,
yes,
I can give on If I not the issue notice.
Yes, let me issue notice at least on an aspect of two, three things.
So otherwise,
Then,
it's not-
but yes, I am aware about
No,
the
no, it's on
decision.
level code under section 27A, under which the suo motu revision was. taken.
Yes, I am that
That-
that
there are
canal
things that-
canal
The bridge.
lot of judgments.
This-
But to that, but with regard to this,
I-
unfortunately, coupled with the fact that prima facie, that first thing is that whenever you are differing from the findings given by
It's not a different. For the 27, the authority has only revised the punishment. The entire order can be
no,
seen.
but the charges which are not proved, you cannot impose
So
punishment.
The show cause notice was issued. Wow, the quantum of punishment.
No, but see, the charges, let's put it this way, the charges which are not proved, you can't impose punishment.
My lord,
for
there are
them.
27 sort of things.
Just a minute, only give me a minute, I'll sign one order.
Very good.
સ્પીકરનું સહી કરવું છે તમે આ મારા corrections છે ને તમારે check કરી લો કદાચ. Yes,
Well, we just kindly have 27 of the booklet to be signed, under which the revision was taken through. May I read?
please.
Revisional power of the state government, inspector general, and deputy inspector general. The state government, the inspector general or the deputy inspector general may suo motu or an application made to him within the prescribed period in his behalf. Call for and examine the record of any inquiry or proceed on of any subordinate of police officer under this chapter for the purpose of satisfying itself or itself, as the case may be, as to the legality or propriety of the decision or order passed by, and as to the regularity of the proceedings of such officer, and may at any time confirm, modify, or reverse any such order. That so he has the power to reverse the order, impose or any penalty or set aside, reduce, confirm, or enhance the penalty imposed by the court.
See then proviso, provided,
Provided that no further individual shall be passed. In a case where appeal against the decision.
no, sorry. No, provided that the order in revision imposing or enhancing penalty shall not be passed unless the police officer affected thereby has been given a reasonable opportunity of.
Given to him.
You were given-
It is there.
Yes, sorry, then,
73.
no.
That is given.
So
to
that
him.
is, so we can only tinker with
Yes.
proportionality.
In fact, this honorable court has wanted section 27A, the power of 27A. This honorable court, there are three judgments which I have read. Which says that the court will not go into it. If ample opportunity is given to him, he has been substantially hurt, which is the case here, the court will not go into the proportionality. The only aspect which now remains for me to go the laws is the issue of proportionality. Of the-
Proportionality, and secondly, whether any when he deviates from the particular, because right or wrong, he deviated from the final.
And made good by the order of punishment that it was not on the merits of the charges of second
Two
charge.
together.
It was just first charge and the punishment was.
File your reply, I'll issue notice. Yes,
Direct service may be permitted.
you have to, now you are dismissed from service.
Yes,
Direct service permitted.
I'm okay.
એની મેટર નહીં ને પછી different છે કેટલી please.
213 matters. Serial number 4, CA 1 of 23, and SCA 1, 224 of 22. Mr. Viber, we are.
Yes, where is
Please.
Mr. Mehta?
He was here.
Yes, what is to be done, Mr. Joshi?
But I have got this 27 July 2018. It has nothing to do with the preparation of the list. It is સીધી ભરતીમાં રાખવામાં આવતી પ્રતીક્ષા યાદીની મુદત અને ઉપયોગ બાબત.
I'm not clear what you say. See, 27 was the waiting list.
27 July 2018 is relating to the time limit and the use of the wait list. That time limit would be 2 years. And it would be used during the period of 2 years or till the next advertisement, whichever is earlier. And if the last appointment is made, then
So it
what-
is not in relation to preparation of wait
not in
list.
relation to the preparation of the list.
So
That is under challenge. Rightly or wrongly, the petition may or may not succeed. But by recording the last line, that the list is prepared in accordance with the extant rules and law, my petition gets rejected at interim stage.
I'm sorry, Mr. Joshi. I still feel that what I recorded is pursuant to the direction
That
and
is absolutely for the honorable court.
Yes.
I must make my submission that
Yes.
by recording this last sentence, my
Yes.
petition gets rejected. That the waiting list is prepared in accordance with law and the rules. Because the honorable court, as we recollect, me and Mr. Vyas, that let it proceed or operated in accordance with law and
See,
the rules.
Will you please read it with me for?
Please, I'll read
At
again.
this stage, it has been pointed out in the what context it has been, because I think I'll
Yes,
be
yes.
able to read my order. At this stage,
It is pointed out.
it is pointed out by London Ms. Maya that there is no challenge to the government resolution.
That's what I'm respectfully submitting.
There is no
27
challenge.
July
And
is
in view of above, it is open for so and so, operate the waiting list prepared in accordance. Then that was.
now kindly see 27 July. 27 July does not relate to preparation of the
No,
list.
what I said. So just go one, paragraph 3.
They have prepared the wait list.
No,
Yes.
no, paragraph 3.
Paragraph-
London Advocate Ms. Vaya appearing for escort number 3
Yes.
submitted they are preparing waiting list and
And
issuing.
issuing appointment orders as per government resolution dated 27 July 2018. Now 27
No,
July.
please read that.
I'll read. She
She
further
further-
submitted that GPSC being government agency is bound to follow the government resolutions and conditions stipulated therein. The role of GPSC is to conduct the examination and make recommendations for the post in question. They have prepared the wait list as per government resolution dated 27 July 2018 for the posts which are subject matter of the present petition. Perusal of the said list provides that separate list for each category has been prepared based on merit each candidate possesses. Now, my respectful submission that 27 July 2018 does not relate to preparation of the list. It relates to the time limit and the use of the wait list. The list has to be prepared as per the general rules and the general policy, which I had drawn the attention of the honorable court that if a person seeks the benefit of the reservation, he becomes a reserved category candidate. If he doesn't seek the benefit of reservation, his name has to appear as a general category candidate. That is the challenge in this matter, that I cannot be treated as reserved category because I have not taken advantage of reservation. I have to appear as a general category candidate. Those persons whose names are being recommended are having lesser marks than the petitioner. I remain general category candidate so far as the list is concerned.
So you say rule of migration would be applicable.
Exactly.
That's what your case is.
Yes, now
But what
this is the
what is-
final list.
What is the hurting? What is hurting you? That the last line that it.
I read it today only. That in view of the above, it is open for the respondent number 3 GPSC to operate the list prepared in accordance with extant rules and law. If this is the certificate issued by this honorable court, my petition becomes infructuous.
So, but it is.
The honorable court wanted them
See,
to
it is
operate the list in
of-
accordance with law,
Well,
not the preparation.
No. It says in view of above, it is open for the respondent number 3 GPSC to operate the waiting list.
Prepared word cannot be there in accordance with extant rules and law. If the word prepared is there, it rejects my petition. I hope I am clear.
So if you mean to say that it is to be said that in view of above, it is open for respondent number 3 GPSC to operate the waiting list.
In accordance with extant rules and law.
Waiting list is as per their submissions, prepared in accordance with law. As per their
The
submission,
word prepared cannot be there.
but they say as per.
This is subject to final
Yes.
outcome, even
Yes.
otherwise. So the word prepared has to go. This
But
is
they say that we are prepared as per.
correct. That is yet to be tested at final hearing or at the admission
Yes.
stage, as the
Yes,
case may be.
yes, yes, Mr. Mehta, what your reply says?
My friend has stated that this is recorded, either you appeal or get the rejection.
Exactly, this
That's
was all
what-
argued. Now let me point out, because apart from what Ms. Paya has to say,
No, Miss Bhaya said the same thing which I
Yes.
told him here in the morning.
please
That-
come to, yes, sir, please come to the reply that I filed.
See, see, Mr. Mehta, I told Mr. Joshi in the morning that last line cannot be read in isolation. It is to be read in context of paragraph
Exactly.
3. I
Exactly.
recorded that it is prepared as per the extent rule, and in that context I recorded. So that is the crux of the order.
Again, as the court rightly says, please go to page 13 of that line that my friend is bothered about. In accordance with the extant rules and law. So it is not specified which GR they are referring to, which resolution they are referring to, which rule they are referring to. They are duty bound to prepare it in accordance with law and whatever the extant rules are. Now, if you are eligible to come to the prayer in the main petition, please see, because I can understand that my learned friend says that you can't do it as per this GR or that GR unless you have challenged that GR. Please have a look at the prayers in the main petition. I can understand your case. He may have a case, for example, saying that GPSC is about to prepare a wait list, but there is a resolution which directs them to prepare a wait list, and
But
that resolution is bad.
But for that, we need to point out the resolution that you have acted not as per
Correct,
this.
correct. And also, if he is saying that this resolution is bad, then resolution has to be challenged. One thing is very clear that suppose there is resolution X for the preparation of wait list. There are two options only. Either that resolution is bad, and my other friend says it is bad and therefore you can't use that, or that the manner in which it is prepared is inconsistent with the resolution.
I am reading right now, limited prayer in the civil application. I right now read it that it is to be read in context with paragraph 3, where I have recorded the facts submitted by Bhaya that we have acted as per GR rated so and so, prepare the select list and it is operate.
My submission, I have a very simple submission. If your ladyship were to grant the prayer in the CA, it amounts to not reviewing this court's order, it amounts to setting aside this court's order.
So that is a larger proposition to be canvassed, but
the court had heard this matter for about half an hour. All the submissions were made, after which this order was passed. And if you are eligible to see now, what they are doing, GPSC is merely implementing this court's order. That's all.
But the last line is in context of the submission.
Yes.
I have not gone into the merits of the
Correct.
matter. They
Correct.
only asked for operation of wait list.
Exactly.
They said we prepared the wait list as per 2710, whatever the
Absolutely.
circular is. And in that context, if they have prepared in that way, otherwise you challenge the entire wait list.
That too, please see, again, coming to the order, because time sought to file reply. So actually, after this court's order, two things happen.
They could have filed
Six.
reply.
So but GPSC still has time, 5-7. In any case, this matter is going to be heard. Reply will be filed before 5-7. Pleadings will be over, and this matter is going to be heard on 5-7. Or let's say 1 week after 5-7. This, in any case, will be the subject matter of the main petition. But today, if my learned friend is aggrieved by this interim order, he has to appeal.
Yes,
No,
I'll
it's not
pass
going to
appropriate orders since I'm having,
It's not going to review.
yes, some matters at 2, I'll pass. I'm not inclined. Please. I'll pass appropriate
Only
orders.
one thing I may just.
Please summarize your submissions.
Please, only one thing I wanted to point out.
Yes.
The marks of the petitioners.
I'm not having this.
181.
No, that I'll not go into that. Civil
Less
application is
meritorious.
only with regard to operation of the
I
wait
follow.
list which she prayed, and I granted. I said earlier order doesn't prohibit you to operate the wait list, and
I
therefore
follow.
I am permitting. I have not gone into anything, and I'll not go at this.
And
stage.
as we have gone as per that law.
But I understand what is calling from
Yes.
the honorable court. I understand English language need not be interpreted by my right hand side.
I'm only addressing the court,
But
not interpreting.
I understand that.
No extra comments, please, sir.
No, I'm avoiding comments. I'm objecting to the comments which are being made.
Many lawyers are waiting, please.
What I'm respectfully submitting is that the petitioners are having more marks and they have not taken benefit of reservation. Therefore, they have to be treated as general category candidates in accordance with the law laid down by this honorable court. Judgments are there. I need not cite judgments in the memo of the petition. That law is that if I don't take the
But Mr.
benefit,
Joshi, that is a matter on
Of-
merits
I
to be
follow.
considered on 5/7.
I
Today,
follow.
limited scope of your civil application that you amend the order passed or you review the order passed in civil application, to which I do not see any
I
reason
follow.
or cause today to any change in circumstances
It-
which require intervention.
Tomorrow it may not be argued that I did not point out these
Yes.
marks. That's why I'm pointing.
No, but I'll say that you try
Please
to
take
argue
care
on
of that.
merits.
Please take care of that. That is the only, please,
After one, two
Anytime.
matters, I'll dictate them.
I leave it to the honorable.
Number 114. Yes. 230. Any order?
Earlier lordship.
Not the final order that. Already there was an order to directing the respondent authorities to implement the recovery certificate, but till date, lordship, they have not taken any step.
So some time period we.
My lord must say that no particular times and they will be paying. Only request is that if my lords may time enough to at least mention that in particular facts and circumstances, then this may not be considered as.
Yes,
because
these are-
otherwise my
Yes, this application is filed. SCA 24109 of 2029, this petition is filed. Seeking inaction of respondent number 2 in not executing the recovery certificate dated
2nd August 2022.
where do I get 2/8/2022 by June. Mr. 2/8/2022. It is case of the petitioner that pursuant to the award of Labor Court, Mehsana, a recovery certificate dated 2/8/2022 has been issued in favor of petitioner. એક છે કે વધારે છે? Petitioner. How much amount? Page number?
Page, annexure A, page 14A, my lord, please.
40?
14A, 14.
Where by?
And immediately after.
Yes.